All right, good people. Happy Friday. Happy Friday. Happy Friday. Let's get into it. Let's get into it because there has been a whole lot of going on up in these streets. And we got to talk about it. We had bombshells dropped today in court for those of you that have been keeping up with the Darrell Brooks trial. Teresa, what is going on? Lady, what's going on? Shayla, hey. TJ, Angela, how are you all doing? It has been so much stuff going on. And today was like no other. We have been watching this stuff. Um, I don't want to speak for anybody else, but I can tell you that I have literally been glued to my phone. It has become a regular part of my work day. You hear me? It has become a regular part of my work day. So I have been glued to the phone. Angie, what's up? What's up? Watching what's going on with this trial. And when I say okay. I'm hoping. What's going on, Atmos? How you doing? I'm hoping that watching this trial will give you guys some type of newfound respect for those of us who are clinicians that have to work with this type of behavior. I hope this gives you a newfound respect for what we have to deal with on a daily basis, because what you're seeing here is live, it's real, in real time, in living color. Y'all are getting it. Y'all are definitely getting it. And the sad part is this stuff would be comical if this backstory wasn't so sad. If the backstory wasn't so tragic. And even the behaviors in themselves, they are sad when you look at where they're coming from. But the actions, yeah. So, like I said, this is the third week of the trial. Let's go. Third week of this trial. Listen, Mr. Brooks, the man formerly known as Mr. Brooks, the guy other people know as Mr. Brooks, the man Mr. Brooks in little letters and big caps, Mr. Brooks in all caps, Mr. Brooks, however you want to put it. He my if you ever yeah, this, everybody got that one child. If you got more than one kid, everybody has that one child. Everybody got that one child. I tell you, what's going on, Big Red? Everybody has that one child. TJ, you haven't heard about this case? This case is taking place in Waukesha, Wisconsin. It is Wisconsin, right? Wisconsin and Wisconsin. So what we have is a young man back in last year, around this time, well, about a month and a day from today, there was this guy, Darrell Brooks, that he drove his car into a crowd of people at a Christmas parade, unaliving 6 people and injuring over 60 people. One of those people that he unalived was an 8-year-old little boy. Now, there are a lot of twists and turns and all this stuff. To me, you can't even focus on the victims in this whole situation because this guy has so much other stuff going on. He has from DV stuff to SA, and like he has all other type of stuff going on. And yes, Angela, in this particular situation, he is one of the people that has. He said that he did not feel like his lawyers were looking out for his best interests. He does not feel that his lawyers were providing adequate representation for him. And he has declared himself a sovereign citizen. And he does not feel that they are providing adequate and that they were providing an adequate defense for him. So he initially came in with 2 public defenders. And he decided, once stuff got started, that he was gonna go and he was gonna take over himself, and he was gonna do it because that's how smart he is. And y'all know everybody's smarter than the lawyers anyway. I mean, shoot, what did the lawyers know? They just went to school for some time and got some license and stuff. But shoot, what do they know? What do they know? It's easy. Anybody can do it. So he has been getting up there, and he definitely has some mental health problems, TJ. Now the thing is, they did somewhat of a competency. I don't want to say a competency hearing, but they did do like it wasn't even a real test. They did something to show that he was competent to stand trial. So this is the thing that I had to that I speak about on my channel at times. Okay, so there's a misconception that if someone has mental health issues or some mental health deficiencies, that they aren't necessarily smart. They can't be intelligent. And I would argue against that, because some of the most intelligent people I know also come along with a mental health label. Now, we try not to put labels on people, but I just want people to understand that the mental intelligence, that mental thing has nothing to do with your actual intellectual level. Two completely different things. So, a lot of people in the chat talking about he's slow, he's stupid. No, he's not stupid. But he definitely has some mental health issues going on. A lot of people said that he was faking. Let me tell you something. You can fake some things, but then it gets to a point where, like, some things you can't fake if you tried. And he is in a place where even if he wanted to act like he was completely in his right mind and of sound mind and body, he can only do it for so long, because he lacks emotional impulse control. And that's what we're seeing every day happen in this trial, because he literally lacks emotional impulse control. He cannot control his emotions. He cannot control his impulses. So he is very impulsive. So the minute something doesn't go his way, the minute something appears that is not going to go his way, the minute he feels frustrated, the minute somebody get on his nerves, the minute somebody turn the light off too quick. Okay, I'm exaggerating a little bit, but I'm just saying, just to give you guys an idea, he lacks that ability to be able to okay, you know what, Brooks, Darrell, tone it down. Okay, bring it on down, bring it on down, bring it on down. He tries to do it, but he can only do it for so long. So when people see him going and people throwing out, oh, he's a psychopath, he's a sociopath, he's a narcissist, he bipolar, and he may well be all of these things. Now, I'm going to jump out there and say, let me first say this. I am not on here trying to diagnose anybody at this particular time. That is not what I'm on here for tonight. We're just talking about what happened with Mr. Brooks in this case in court and all the other stuff that he has going on. So it's a lot. It's a lot. And with him defending himself, that also gives him the right to not only go through the paperwork, have access to all the documents, but he also gets to victimize. That's what I'm going to say. Victimize, re-victimize all these victims and people that were a part of this whole situation, because he gets to question these people on the stand. And when I say, okay, let me stop. Let me just stop. Well, this was going on, Pico. Let me just, oh my goodness. So what I'm going to do is, I don't even know where to start. I'm going to start with his, we're going to start with this morning. Okay, like I said, this has been going on for 3 weeks, but I just want to give you guys, if you saw the little video clip I put out today, that was just one small outburst that he had today. And that was just because of one thing that the prosecutor said when they actually pulled his car. Because let me tell you something. People have been pissed with this judge in this situation, thinking that she does not know how to do her job. Let me clue y'all in on something. okay, with over 20-something years and some level of law enforcement. That judge, let me tell you something. He better thank God he got that judge. That judge is disciplined, okay? Because for her to sit there, for her to sit there and take the emotional abuse that this man is putting just towards her, y'all. When I say that he is mentally abusing this judge, and she's sitting there taking it like a champ, and you can tell that she's getting frustrated. Lord have mercy. What's going on, Shay? You can tell that she is getting frustrated, and she's trying to hold it all together. And Lord, she probably praying that she can. Oh, I'm praying for her. Okay, I'm praying. She praying that she don't come at this dude the wrong way, because she's doing everything that she can to avoid him trying to file an appeal based on him like doing all this mess in court, because that's what he's going for. He's trying to get that mistrial, or he's trying to get an appeal. Okay, let's do this real quick, because people have been doing polls. They've been talking about, oh, they might find him not. It's not possible for him to not be found guilty. Okay, this is the same thing like in the Parkland, well, not the same thing, but similar to the Parkland shooting. It's not about whether or not he did it, because that's what people are overlooking. Even though he has all these antics in court, he never denied doing it. What he's saying is, you say I did it, prove it. Okay, his argument, because people say I don't understand the argument, his argument is, was it intentional? Because a lot of his charges had to do with his acts being intentional. And that's what people aren't saying. That's why he's asking some of those questions that sounds like they're just redundant and just off the wall. That's how I know by listening to him that he is not as slow as people think he is. He's not slow. That's why he keeps, every time the jury gets ready to walk in. I even took note yesterday when he said, oh, the jury's coming in, and he leaned up to the table and he started his little mess. Is that a judicial determination that you're making? We got to talk about jurisdiction. He starts doing this stuff every time the jury walks in, because he wants them to know exactly what's being said when they're having their little internal talks and they putting him out, the jury out the courtroom. So every time the jury walks in, he comes with this same stuff over and over again to make sure that the jury gets just a little earshot of what he's saying about this jurisdiction and all these judicial determinations. And just, it sounds like a bunch of bull. It's a lot of sovereign talk. The judge is hip to it. She is not slow by any means. But y'all, let me just let y'all see a little bit. Let me show you how today opened up. Okay, the other days, he has been able to maintain himself at least until about 11 o'clock. He starts cycling at 11 o'clock. Okay. I'm going to say he starts cycling about 11 o'clock. If he was on medication, that means that medication, it starts cycling a little bit at 11, and the turn up is on, and you about darn near need another dose. And I ain't saying he on medicine. I'm just saying that's just an example. But this morning, he didn't make it at 10 o'clock. He didn't make it at 9 o'clock, as a matter of fact. He did not make it to 8:45. Okay, he woke up ready this morning. So I'm gonna just let y'all see a little bit for those of you who are not familiar with the incident. This child. Well, TJ, you didn't miss it because it's not over. It's not over. I'm gonna go. It continues on Monday, because for those of you who are not aware, his mom actually received a subpoena to testify by the state, and they never called her. Something happened, basically, like she won't coming in. I don't know. So he made a point today to say something about his mom, and he's saying that he wants his mom to testify. Those of you that saw my video the other day about this, you see that the mom had already spoke on some of his behaviors, and she even said before, she basically was saying that he had bipolar disorder, basically, because she was saying, you're going to see his manic stage, you're going to see this. It's a little bit more. He definitely has some borderline personalities, but we're going to keep on moving, and I'm going to show you Shade Child. Let me tell you, if you pick up on Monday, That's going to let you know how the rest of this is going. From the first week with him taking off his shirt in the courtroom, they keep having to remove him from the courtroom and put him in a second courtroom, and he has to listen over there. So he's doing like a virtual trial. He's taking the shirt off. He's holding up, let me not put that up. He's holding up a sign. And on the sign, it has objection. Okay, this is what they had. His arms got tired. He take the objection sign, stick it in the front of his pants, and hold it up there so he can just do a 24/7 objection. And when I say completely disrespectful to this judge, and she has been taking it. But let me tell y'all something. I don't care how much God, let me not say I don't care. Lord, please forgive me. But it does not matter how much God I have in me. I'm only going to let you go so far, okay? I'm only going to let you go so far. And yeah. I'm only going to let you go so far, and I'm going to have to give you, God, you know my heart. Okay, I'm going to have to give you one of those. I'm going to have to give you one of those. Because, I mean, it is to the point of him being abusive to the judge on the stand. So I can't understand why they would let him represent himself if they know he has some mental health issues. I just don't understand the law. Because the thing is, TJ, this hair is giving me the blues, y'all. I'm sorry, I just washed my hair. The thing is with that, a lot of the people that cycle through the criminal justice system have mental health issues. Whether they're coming through the juvenile justice system, whether they're coming through the adult penal system, a lot of people, as a matter, there are very few that don't have some type of mental health issues. And the thing is, they gave him representation, but if he refuses to accept that representation, because he literally had 2 attorneys, he turned it down. And once, and he put up a fight for that. So, okay, the judge okay, I'm telling you, you can't handle this. The judge just had to, bruh, you sure you want to do it? Bruh. She did everything, but bruh. You sure you want to do it? You sure you want to do this? You understand that you facing consecutive life sentences? Are you sure that you want to let these attorneys go? And he, the big dog, and he just, I got it. I can read the, okay, hey. Judge said, well, go on with your bad self there. Rock on. And even with her doing that, and even with him doing all of this buffoonery, y'all, she still gives him the benefit of the doubt. Shoot, the prosecution gives him the benefit of the doubt. Okay? When they see he don't understand stuff, they explaining it to him. When he doesn't have paperwork, and he can't find paperwork, and he can't find evidence, and he don't have videos, none of that stuff. So the prosecution is going and helping him with his defense by finding the location and the video where stuff is he want to see. He can't find the paper. They going in their little notebooks and they files getting paper so that he has his stuff. They are literally, there is no way. The only way that he can appeal is if he said that they acted in his favor. Because he for darn sure can't say that they were against him. Because they have literally done everything that they could to make sure that he could not file an appeal. And that's all the way around the courtroom from the judge and the prosecutors. When I tell you that this is a game that you guys have not been privy to before, that's why people what the flip is going on? Let me stop talking. Let me let y'all see just how today started. Now, mind you, he is very mild. I don't want to say mild-mannered. He would appear to someone that was not familiar with his other behaviors, he would come across as being mild-mannered initially, but give it a minute. And I want you to notice how things change. You will notice the change is coming because you will start seeing a physical change in his facial, I'm going to say his facial features, his whole makeup in his face. You start noticing the face change, his body, his mannerisms just start changing as he as he turns into the Incredible Hulk. That's what I'm gonna call it. As he turns into the Incredible Hulk, you can start see this. You see it manifesting while he's standing right there. So let me go. Let me get into this. Let me show y'all Mr. Darrell, Mr. Brooks, him, whatever he's choosing to be on this Friday, I'm gonna show y'all him. And we're gonna go from there. So bless his heart, Jesus. Bless his heart. Bless his little asthmatic heart.
I merely seek to put you on notice, on the record, for something that needs to be brought to your attention
and
to the court's attention.
And I will address it.
That's what I'm merely seeking to do. It's something that shouldn't have to wait because it'll take up valuable time later. At least if I notify you right from the onset, you'll already know what we're looking at, and we can nip it in the bud before everything starts to roll.
Mr. Brooks, I will address it at the next break. If you want to write something down, that's fine, and give it to my clerk. I have nothing in writing. I know there's witnesses available and ready to go.
Look at his eyes.
Your Honor, you have to answer this question. That's your judicial determination.
Call your next witness, please.
You're rushing to judgment, Your Honor.
There's no rush to judgment.
There is a rush to judgment. If you want to address a legal issue, that I informed you that I have some legal issues that need to be addressed before you just run right past that, Your Honor.
Mr. Brooks, it is 9:37. Call
It is
your
8:37.
sorry, 8:37. You're right. Call your next witness.
Your Honor, you're rushing to judgment.
There's no rush to judgment. Call your next
You
witness,
have a
please.
legal matter that needs to be addressed, and I'm really trying to
Can I
notify the court.
telling you I'm denying the request to address it at this moment. Call your next witness.
Say what?
I'm denying your request to address it at this moment. You
How
call,
can you deny
please,
something that we're supposed to do before
Mr. Brooks. Call your
I'm
witness.
not seeking to be disruptive. I'm just seeking to understand why all we do is
Everyone is in the courtroom waiting for you. Please call your next
We do
witness.
this every single day. We've done it every single day. So I'm simply trying to make sure that the court is notified.
Put it in writing, hand it to the bailiff, and if I deem it important enough to interrupt the witness, I will call your next witness.
How can I call a witness and write something down?
You can take a minute to write down what it is. I'm asking you,
why it needs to be addressed beforehand.
Mr. Brooks, the jury is remaining in this courtroom. Call your next witness, please.
Your Honor, you're rushing to judge.
There's no rush to judgment.
Are you not a public servant, Your Honor?
Mr.
Your
Brooks,
Honor,
First off, let me just pause this for a second. First of all, now in the environment that I work in, now this may look like a regular stance. Let me just back this up for 1 second for y'all. This may look like a regular stance to y'all, but in the environment that I work in, hold on, let me try to get it. Hold up. Let me play it. So
the
I can get it
jury's
to that
here.
spot.
You're doing this.
listen,
We need to go
I'm
forward.
I'm not attempting to delay the proceedings. I'm not attempting to be disruptive. I'm merely trying to notify Your Honor in the court for the record beforehand. That way, everyone's at least on notice of the issues that need to be taken up instead of waiting until a break or a lunch and things of that nature, which kills
In my
valuable time.
discretion, it's my authority. It's the courtroom that I'm presiding over. I'm not going to address it at this moment.
Is this not your
And I'm
oath?
not going to
Did you
answer
not
questions.
swear as a public servant that you would protect the
Mr.
United
Brooks,
States Constitution?
Call
Did you not do that?
your
3
witness.
times. I have all of them here. Your oath, Your Honor, as a public servant.
Okay, first of all, let me just go back to that stance when he put his hands behind his back like this. Like this. Okay. Now, to the average person, that may seem like, oh, he's good. No. In the environment that I work in, that's actually one of those stances to let you know I'm ready. Okay? That's one of those stances. Okay. That's that stance I'm going to give you before I'm about to swing on you. But who am I? But you got the unmitigated gall to go and tell the judge, aren't you a public service? Ain't this your oath? He went and got child. Let me tell you something. Let me tell you something. Somebody looking out for this child.
And
Mr.
now you're
Brooks,
rushing me to judgment
there's no
when
rush
I'm
to
doing
judgment.
things lawfully by trying to notify you and notify the court of issues that need to be addressed
Mr. Brooks,
beforehand.
We are in
These
the
were issues-
evidentiary phase of this trial.
Your Honor,
Call your next witness.
You're rushing me to judge me, Your Honor. And I object to
I'm
that.
aware of 3 witnesses who are here. Call one of them, please.
Your Honor, I object to that.
Your objection's no.
And I want a legal reconsideration of your ruling. If not, I reject that ruling and take exception to that ruling.
I understand.
I request a legal or factual basis for your ruling, a written judicial finding of fact and conclusion of law for your ruling. And if not that, an interlocutory, declaratory appeal for this matter. And if not, these need to be stayed until this matter is before adjudicated court of competent jurisdiction, because we have not proven jurisdiction in this court as of yet. Subject matter jurisdiction has not even been proven on the record, Your Honor. I don't even know the true nature and cause of the charges against me. I don't even understand that part.
I understand your request.
Provided a complaint. I haven't, Your Honor. There's so many issues.
Mr. Brooks,
I'm not attempting to be disrespectful in any way.
We need to continue. Your requests are denied.
Your Honor,
and I'm going to instruct the jury at this point to disregard and not consider any of what has just happened since you walked in. It should not be held against Mr. Brooks in any way. These are legal issues that this court may or may not need to address, but they do not bear in any way on ultimately the issues that you as jurors will have to decide. And I'm instructing you to disregard what you have just heard and seen.
I need y'all to understand that the judge is telling the jury to disregard his ignorance at this point. What judge does that? What court does that? She's telling the jury, yes, he is up here acting a donkey, but do not let this affect your decision making whenever you guys go back to deliberate. Please overlook his buffoonery.
Your Honor, with everything that I just said, be made part of the record.
It's on the record. I'm telling the jury that it shouldn't affect anything that they're doing in any way.
Your Honor, it's a rush to judgment.
Mr. Brooks.
Because, Your Honor, I just showed your oath that you swore to took. You swore to use
Mr. Brooks,
Your Honor.
Please call your next witness.
You took these oaths of offices. You did, Your Honor, 3 of them.
I understand my oath,
which is
sir,
very,
very
very
well.
Commendable that that you decided to be a public servant in these type of matters, Your Honor. I respect it to the fullest, but also you have to uphold these oaths.
All right, I'm going to have to excuse the jury since Mr. Brooks is not calling his witness. We'll hopefully bring you back out shortly.
You have to honor these oaths of offices. You have to, as a public servant, Your Honor. I respect you being a public servant. And this is not to take a shot at you in any way, but these issues
Brooks,
that I have,
stop. Please
they
stop.
need to be addressed. I'm
excusing the jury. Can you please stop?
Your Honor, this is a rush to judgment. This is a clear bias.
Mr. Brooks, you are to stop talking.
Are you asking me?
I'm advising you, or you will forfeit your right to be present in this courtroom for the questioning of your first witness.
Because you're holding me in contempt.
I'm not holding you in contempt.
Then how can you remove me from the courtroom when I haven't given consent?
Mr. Brooks, I'm advising you at this moment to call your next witness, or you will forfeit the right to call these witnesses.
You can't take
under 906.11. You are refusing to call a witness.
I didn't refuse anything, Your Honor. You can't deny me my 6th Amendment right, which is
Mr.
to
Brooks,
call
do you want to be present in this courtroom while you question your first witness? Because it is now 8:44, and you've consistently talked in front of the jury who's no longer in this courtroom on issues that you have been advised and are fully aware are not relevant to their determination, despite what you believe the law is. Subject matter jurisdiction. That is what you referenced in front of the jury, and then you referenced my oath. Subject matter jurisdiction, as you know, is not something the state has to be. The state must prove.
It has to be.
You are completely confusing civil jurisdiction in federal cases with criminal court jurisdiction in the state of Wisconsin.
That boy said show him lawful law now.
Subject matter jurisdiction or personal jurisdiction.
So show him lawful law.
You don't. You haven't.
You have not. I excuse the jury. I'll give you the opportunity to raise whatever issue it was, but you need to do it now or we're moving forward.
That's what I want to do.
What's going on, Ms. Ty?
And if you interrupt me one more time, you're going to go do it from the other courtroom. Because
so
you're
being
all right. He can go to the other courtroom and we will address these issues because you are not being respectful. You are disruptive. You are interrupting. I will give you one more opportunity. Don't interrupt me again. Don't roll your eyes at me. Don't sigh at me. You have delayed these proceedings now by 15 minutes because of your nonstop.
I need y'all to remember something. Let me remind y'all, this man is 40 years old. Okay, this is not a child. Contrary to what you guys may be seeing on this screen, he is not a child. Okay, I have so much respect for this judge, but let me tell you something. You got to have a certain degree of stick-to-itiveness, okay? There has to be a level of stick-to-itiveness. So if I tell you that I'm going to bounce your gluteus maximus about my courtroom, then that means you got to go. Ain't no one more chance. I'm going to give you one more chance. Judge started sounding like Biggie Smalls, okay? She kept giving him one more chance, and I get it. He wants her to hold him in contempt because that would drag things out. That's what he's going for. That's what he's going for. So that's why I keep saying, are you holding me in contempt? Are you holding me in contempt? All I'm saying, you holding me in contempt. So that's why he coming at her all, foul like, but child.
Commentary. I'm going to sit down and I'm going to listen to you. What issue do you want to raise, sir?
So are you letting me make an offer of proof for my appeal?
No, because that's not what's relevant at this time, sir. If you don't need to make an offer of proof. Tell me what the issue is. You said you have a legal issue you want to raise before we get going. What is that issue?
Okay. The legal issue is this. Detective Casey yesterday testified for the second time under oath in reference to exhibits 13 and 14. That showed which he stated.
What's going on, Miss Fat? That's one of them HBCU words right there. Stick-to-itiveness.
All this stuff when he did not, in fact, even speak with my mother. It was brought to my attention that my mother, in fact, never spoke to any law enforcement from Waukesha.
Would you like to add her to your witness list to call her?
Yes, I would.
All right, that's
because
fine.
she's willing to come.
But that's not something we needed to address this.
So this is where the mom comes in at. But let me tell you, he done lied on his mama a couple times. Okay, he done bless his mama little heart. I'm gonna take this up a little bit further because I want
him as well.
No, I don't think it'd be necessary. You know what he did.
To talk about his witnesses that he's calling to the stand. This is where it gets a bit more interesting. So his thing was, I'll let this play while we get to that point. His thing is, he was supposed to have his ex-girlfriend, his child's mom, on the stand today. Mind you, he has already questioned her once.
Good morning, sir. If you would please make your way to the witness stand, which is up toward me, up one riser.
He's recalling her to the stand, right?
Raise your right hand. My clerk, Teresa, who's on my left, is where you at.
Hold up. I think I passed it. Hold on.
You don't have it with you in the...
So these are the prosecutors in the case. This is the main prosecutor right here, Miss Susan. And then, this is her team. And y'all, even yesterday, I got to go back to yesterday because she got so fed up. Miss Lady right here, that not only did she go off on Darrell, she went off on the judge. She told the judge, you should not let him be doing this in your courtroom. He is completely disrespectful. We understand what you're trying to do. We appreciate what you're trying to do, but he got to go. She was like, Judge. Now, let me say again, the situation behind it, yes, he is, it's tragic, but watching him, let me tell y'all something. Being in and out of the courtroom, I'm going to say this and I'm going to get back on here. This reminds me, and I can say this now, but we're in court and somebody broke into someone's house and we're in court, and the person did not realize that the person's house that he broke into, the person's house that he broke into was the prosecutor, one of the prosecutors for the area. And the judge asked, "What did you take?" And he said, "A DDD player." Judge said, "Huh?" She had her glasses on. She said, "Excuse me, what did you take?" He said, "A DDD player." The judge said, "So you mean to tell me you stole something and you don't even know what it is?" Now, see, if this was the judge, Pico, he has, let me see, I think I wrote him down. Hold on. He has a lot of charges. Let me go back. God, do I have all his charges? I had to go back. He had a lot of stuff. Yeah, a DDD player. DDD. He has a lot of charges. What I do is I'll go back to the preliminary so that you can see that he's loaded. He has a lot of stuff going on. Mind you, he had also been charged for the ex-girlfriend who actually is a witness in this case that he has already questioned before, and he actually called her back today. He actually was charged with hitting her with the car and Lord, strangulation. He has a history of strangulation, suffocation, battery. He had 2 counts of reckless endangerment, where he fired a gun at a car with his nephew and another person in it. Domestic violence, another charge of battery, statutory sexual seduction. And this is also with the girlfriend, the ex-girlfriend that he has the child with. She was a minor whenever he got her pregnant, and he had to go to court for that. He pled guilty to that. He struck the mother of his child with the closed fist and then ran her over. It says ran her over. He ran over a foot, but he still hit her with the vehicle. He has a lot of stuff going on. So he has like a lot of bail jumping and all this kind of stuff. So all the stuff, and he committed crimes while he was still on probation, while he was already on some other papers in this state and then some other, like he committing crimes all over the place. He got crimes in Georgia, Wisconsin, like Willie Coochie, like he got crimes everywhere. Pico, he definitely has some stuff going on. So I'm saying they did not go the charges that they discussed, because they did discuss his criminal past, but they only went back to the age of 19. So I'm thinking that what they did was they chose to, if his records weren't sealed, they basically sealed his juvenile records or decided not to include those records in his criminal history for this particular case. Because I'm not going to believe that at 19, he just started acting out at 19. So if I was seeing him as a teenager, as a juvenile, I can definitely see oppositional defiant disorder. I can definitely see conduct disorder. He definitely has some of those things. So those would be like the initial things as a child that I could see him possibly being diagnosed with. Now this look a little different as an adult. So like I said, the charges started at 19. His stuff dated back more than 20 years, 21 years. Just with the stuff that they discussed. And like I said, it started at 19. So the behavior that we are seeing right now, imagine his mom and his family, and even the girl, she's dealt with him. She said she's been knowing him and dealing with him for 16 years. And I think they have a 15-year-old. So 15 or 16. So he's been doing this stuff for a long time. These behaviors have been just out there and just based. I'm trying to make sure I say this the right way, because you still want to be not just sympathetic, but empathetic whenever it comes to certain things that happens to people that are dealing with mental illnesses. But his I don't give a F that come along with this, and his thugness, because he tried to be a thug too and a rapper. When you put all that stuff together on top of what you already got going on, and then no offense to nobody, but he like to partake in the cannabis, and I can see that he done been using that cannabis for a long time because he done burned a couple brain cells too. No offense to anybody that use cannabis, you got to smoke a lot for it to get to the point where it starts burning those brain cells. But do know that once you burn those brain cells, they do not come back. That's all I'm saying. When they gone, they gone. But child, let me go out because I'm looking like I'm frozen. Hold on. Okay, let me try this one more time. Because it appears that I am frozen. Can you hear me? Okay, there it is. Yeah, I just went down, y'all. The thing just froze up. It froze up on me. I guess because I was playing the other people's video. I don't know, but it froze up on me, child. Okay. But yeah, so the stuff that he has going on, I definitely see some oppositional defiance there, but that looks a lot different as an adult. Oh my goodness. I don't know what part y'all heard and what part y'all didn't. So let me get back into this video. I want to find the spot. Hold on. Hold on, y'all.
You recall stating that.
And you also are excused. Thank you for being here. Call your next witness.
Okay, so this is where he questioned the first witness that he had on the stand, which claimed he didn't have the paperwork for, act like somebody stole his paperwork. So they're giving him an opportunity to call his next witness. And I'm gonna let y'all see what happened. Let me just show y'all what happened. Like I said, it was a whole lot of going on today. And he started off early this morning. He did not give that judge a break today.
If I may have just a quick second.
Okay.
The defense will call Stephen Guth.
Nah, that ain't it yet. Hold on.
I believe one of my assistants went to retrieve Detective Guth, Your Honor.
Hold on. Hold on.
Us, and so I told you that 3 witnesses would come in at 8:30, 2 would come in at 10:30, 2 would come in at 1:30, 2 would come in at 3:30, and then if there were any left, I wasn't sure if there were or not, coming in at 4.
You also didn't provide me with that list.
You were advised on the record,
But sir, you didn't provide it to me.
Sir, you chose not to write down. So that's on you, not me.
No, that's
So
no.
here's the thing, Erica Patterson is here, so I'm advising you that she will be the next witness that you call if you so choose.
Okay, context. I'm sorry. Erica Patterson is the ex-girlfriend, his child's mom, one of his children's mom that I was speaking of. He wants to question her a certain time of the day. He wanted to question her at a certain time because his plan was to keep her on there and just badger her for all this time. What happened was they gave him the opportunity the day before. They told him the judge asked him to give her a list of all of his witnesses in the order that they were going to be going in. He refused to give them an exact order. So the judge, along with the prosecution, once again, I'm telling y'all, the prosecution is doing, I don't want to say favors because that sounds inappropriate, but they're literally doing his work for him, the prosecution. They are going and they're finding the witnesses that he wants on the stand. They are issuing subpoenas for his witnesses and making sure that his witnesses show up for court to testify for him. And so that's where they're at. So he chose not to write the list down, the names down in the order. And he's expecting he's holding the court responsible for the fact that he decided not to write the names down the day before, even though the judge told him to write the names down. So that's where we are with this. Let's carry on.
If you choose not to call her right now, then I'm releasing her from the subpoena.
What's going on, Bruce?
We have almost 45 minutes until 10:30, just slightly under that. And there's no reason for you not to call her. She's on your list. She was on the listing as I understand it, the groupings of 3, Tuesday morning, Tuesday afternoon, Wednesday morning, Wednesday afternoon, and so on and so forth. That's the order. I told you very specifically, I'm not going to have everyone come in at one time because that's not efficient, that's not effective, and it's not courteous to them. People have families, people have jobs and other responsibilities, and we're trying to be mindful of all of that as well while having the state assist you in getting these people here. So I'm advising you that if you don't call her right now, you will forfeit your right to call her.
Is that lawful law?
Sir, I believe I have the authority to do that. She's here. She's ready to go.
I'm just
She's
asking
your
a question.
witness.
I'm just asking the question. Is that lawful law?
I have the authority under 90611 and other rules and the inherent authority of this court to control the order and mode of interrogation.
Your Honor,
of witnesses.
why is it always so hard to just say yes or no?
Yes,
is it lawful
I have
law?
the authority,
Mofo, who you
I'm
think,
not
boy?
disputing that.
You just
I'm not disputing.
that.
No, I asked the question. Is it lawful law?
Sir, I told you what I believe my authority is. Okay,
You
if you
told
don't
me
want
what
to
you-
recognize it, that's
told
fine.
me
You
your
want to
authority.
object and note it,
You
that's
told me
fine.
your
The
authority.
objection
I'm
is
not
noted on the
debating
record.
your authority. I'm not.
So I will address one other issue with you because you said you had an issue regarding the last witness, which is fine. We can address that quickly, and then I'm going to have the jury brought in, and that will be your opportunity to call
That's a
Ms.
misdirect.
Patterson.
That's a misdirect. What issue did I say I had with the
You
last?
said you wanted to raise
said-
an issue with about
What
Detective
I said
Guzman's
was I
testimony.
might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow
I may
nobody
have
hears
missed
me.
it, but I heard what I interpreted was when you said I may have an issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. Are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right, then that will be noted, and we'll keep him under the subpoena. Now, that should address that. I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. You can't. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that.
And so then I asked you
Your
to
Honor,
put
with
him
all
in
respect,
flex.
did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks,
Numerous
I have
times.
authority.
Let me say this real quick. Let me just say this to the people that aren't aware. Okay, just because you say with all respect, or I don't mean to disrespect you, or no disrespect, but that lets a person know that's just a precursor of the disrespect that is yet to follow. Okay, I don't mean to bother you, but yes, you do. I ain't trying to be rude, but I know it ain't my business, but, and you proceed to go and get in somebody else's business. It is the same thing. So just because you start a sentence off with, all due respect, with all due respect, bruh, right, Angela, sane and coherent. He just got some issues, but he's dead. And that's the point that the judge keeps trying to make, even in the midst of his extinction burst, even in the midst of all of his outbursts that he has going on, the judge will go back and give him kudos for following the case and being able to question people based on stuff that he's heard on that stand. So she keeps reiterating that. So if anybody tries to say that this guy was not intellectually capable of defending himself, the judge has it on record. No, he's very smart. She's very smart. He's very smart. And she seems to placate him a little bit, but it's not that she just fell for the okie doke. It's not that she's drinking the Kool-Aid. She understands what she's working with. She understands what she's working with. But child, I'm gonna tell you, I don't know if I can keep working with this one, but
to tell you otherwise.
Child,
you may not like it. You may disagree with it.
It's not about that. It's about the rush to judgment.
You have not been cooperating with this process. The
There's
state
nothing
has
to cooperate
graciously
with.
agreed to assist you given your custodial status.
Okay, and I never asked them to do
any
that.
attorney in this
I
situation
never asked them to do that, Your Honor.
would give us the order.
Did I or did I not?
Now, this little ungrateful child, let me tell you something. Do you see what I'm saying? That's why you can't do stuff for certain people. Because they done went and bent over backwards and did all this stuff for this dude that they absolutely should not do. And then he gonna have the nerve, the audacity to come out the side of his mouth and say, I ain't asked him to do that. Really, bro?
Did I ask them to do that? I did not ask them to do that. They volunteered.
They offered.
So at the end of the day,
but we expect
if they didn't want to do it, yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor. Let's
no, common courtesy is the stipulation.
Okay, but it wasn't stipulated to, so I didn't have.
You are well advised.
Bro, you didn't stipulate the common courtesy. You said, my God. That boy say common courtesy wasn't stipulated to. That wasn't one of the stipulations of them getting his subpoenas issued. If you don't go to child, if you don't lawfully go sit your tail down somewhere, you put these people through a whole lot of stuff that they do not need to be put through. I mean, you giving other people some trauma just based on your own behaviors on this child.
This was gonna go.
No, I was not.
It is
because
normal
if you
in a trial.
You can't put the people. You can't put the people in a specific spot for me, Your Honor. Come on now.
It is.
That's a rush to judgment.
There's no rush to judgment here.
Did the state have to put their witnesses? Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
Why are you not an attorney?
Did they have to do it?
No, they did not.
I didn't have to be provided with. We're going to call this witness at this time,
but they're
this
able
witness at this
to
time.
Contact
They didn't have to do that, so why should I have to do that?
Because you don't have your Juris Doctorate, bro.
It's not about the state. It's about the witnesses.
It's about what's fair. It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with a shock device on my ankles. So how's I'm trying to control anything? I just want this to be fair, and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to me how that's fair.
The process that has been set up to frankly help you.
No, it's not helping me it's helping the state by being able to say, if we know the time and we know the person and we know this, then we can be prepared. So we'll already be ready.
Mr. Brooks,
that was the whole aim of that.
And I would have had her come in later. You didn't.
First off, let me say that the officer in the background, let me see if I can get back on him for a second.
There was no question to answer.
Is the real MVP right here for keeping that poker face in the back. He is the real MVP. Because ain't no way, bro. Ain't no way. Ain't no way, bro. Child, let me.
I did what you asked me to do, Your Honor. You said, yes, you did. You did. You asked me to give them my witness list.
Brooks,
I gave them my witness list. It's not my fault. It's not my fault they weren't going to be prepared to
Mr.
do
Brooks,
their
here's the deal.
to do
the
their
jury's
cross.
Coming out, and I'm going to stand my ground on this.
I'm gonna stand my ground too, but I'm not going to be disrespectful or disruptive. I'm just stating I want it to be fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that. Where's the lawful law? Where's the lawful law? I have the right to witnesses.
You have to cooperate with this process.
But I also have the Sixth Amendment right.
We have a witness available for you to call. I can require.
It's not the witness that should have been called at this time, Your Honor.
It is based on the list that you provided, and
that didn't have a time. That didn't have a time or
I'm not going to play
order.
This game with you. Sir.
It's not no game. That's what you don't seem to understand.
Here it is. Here it is.
I don't care what you believe fully.
All right.
It's not a game. I don't take this as a game. That's what nobody. That's what nobody. You don't got to explain nothing to me. That's what you don't understand. You think that this is a whole game to me. This is not a game to me, Your Honor. Nothing about this is a joke. That's what y'all don't understand.
He's working himself up.
But
and it's unfair. It's unfair and it's disrespectful to me that you think I would come in here purposely and treat this like a joke or a game?
I never said it was a joke.
What type?
Hold on. First of all, you need to sit your tail down when you are talking to me. Hold on, child. First of all, First of all, you need to sit down when you are addressing me in my courtroom. First of all. Second of all, if you don't sit your little tail down somewhere, you better go lawfully sit your lawfully tail down in that seat and act like you got some sense and some common decency and decorum in my courtroom, bro. You gonna stand up on me? Listen, child. See, this some Waukesha stuff right here. Cause once you stand up, ooh. She has given the officers, the prosecution, everybody in the courtroom, she has given them strict rules and what to do and what not to do when dealing with this man. Once he got all swole up in his chest. What's going on, Lady Diva? Once he got all swole up in his chest, okay? Once he act like he want to get that bouncing action going on, Houston, we got a problem. That's what I'm saying, because you try to remember the fact that you try to understand him because you know that he got some mental health stuff going on. But bruh. Ooh, Jesus, keep me near the cross. I tell you both. I tell you now.
What type of statement is that? Your life is not on the line. Mine is.
Oh, wait a minute.
What type of statement is that? Your life.
Oh, right there. Y'all didn't even get to see it, did you? Y'all sitting here looking at me. Hold on. Y'all done met child. Hold on. Let me rewind it back. Y'all heard it. Y'all didn't see it. Hold on. Let me take it back because y'all got to see this. Ooh, child. I gotta put this on the big. Hold up. Watch this joker.
That I had with the
You said you wanted to raise an issue with about Detective Guzman's testimony.
What I said was I might have more questions for that witness. I didn't say it was an issue.
Oh, I didn't hear that, sir. You had your opportunity to ask the witness questions. He's been released.
Your Honor, if I mumble something under my breath, somehow that's audible, but when I talk clearly, somehow nobody hears it.
Oh, Shay, he does start yelling. He starts yelling.
What I interpreted was when you said I may have an issue with this witness. I didn't understand. I guess I didn't take that as you were going to reserve your right to recall him. Are you telling me you'd like to reserve your right to recall Detective Guth?
Yes.
All right. Then that will be noted, and we'll keep him under the subpoena.
He blowing his breath and stuff like he's tired of them.
I'll have the jury brought back in, and you should be prepared if you choose to call Ms. Patterson. This is your opportunity to do it.
At the same time, though, that's still a rush to judgment, Your Honor. I shouldn't be forced to call people in the order that I'm being told to when these are my witnesses.
You did not want to provide us with the order, and I respected that, Mr. Brooks.
But I said that.
And so then I asked
Your Honor, with all respect, did I not inform Your Honor in the court that I would not give a specific order? I stated that numerous times.
And Mr. Brooks, I have authority to tell you otherwise. You may not like it. You may disagree with it.
It's not about that. It's about the rush to judgment. You have not been cooperating
with this process. The state has graciously agreed to assist you given your custodial status.
Okay, and I never asked them to do that.
Any attorney in this situation,
I never asked them to do that, Your Honor.
Would give us the order.
Did I not? Did I ask them to do that? I did not ask them to do that. They volunteered.
They offered.
So at the end of the day,
but we expect
if they didn't want to do it, yeah, but that wasn't one of the stipulations when they offered to do it, Your Honor.
No, common courtesy is the stipulation.
Okay,
sir.
but it
And-
wasn't
and here's the
stipulated
thing.
to, so I didn't have.
You are well advised of how this process was going to go.
No, I was not.
It is
Because
normal
if you-
in a trial.
You can't
to call
put the people.
witnesses
You can't
out
put the
of
people
order
in a
based on
specific
their
spot for me,
availability.
Your Honor. Come on now.
That it is.
That's a rush to judgment.
There's no rush to judgment, Kara. You
Did
keep
the state
saying that, sir,
have to
but
put
that's
their
not the
witnesses?
case.
Your Honor, with all due respect, did the state have to put their witnesses in order and tell me?
It's irrelevant what the state did.
Did they have to do that?
They didn't need your assistance to do that.
Did they have to do it?
No, they didn't.
I didn't have to be provided with. We're going to call this witness at this time.
But they're
this
able
witness at this
to
time.
contact
They
their
didn't have to do that, so why should I have
and
to do that?
accommodate their schedules. This is not about you. It's not about the state. It's about the witnesses.
It's about what's fair.
availability.
It's about what's fair.
No, frankly, sir, it's about you trying to control what's happening in this court.
How am I controlling what's happening? I'm the one shackled to the table with
So here's the
with a shot
situation.
device
It is
on my ankles.
9:52.
So how's I'm trying to control anything? I just want this
I'm
to be
going
fair,
to-
and it hasn't been fair.
Mr. Brooks, it's fair.
No, it's not. If I have to do something that they don't have to do, how's that fair?
It's fair.
Explain to
because
me how
of
that's
the
fair.
process that it has been set up to frankly help you.
No, it's not helping me by it's helping the state
And no,
by being able to say, if we know the time and we know
You
the
did
person
not-
and we
I
know this,
asked you-
then we can be prepared. So we'll already be ready.
Mr. Brooks,
That was
I
the
asked
whole
you
aim of that.
yesterday, and I would have had her come in later. You didn't want to answer that question.
There was no
And
question. It was no question to answer.
That's not
I
true.
did what you asked me to do, Your Honor. You
No, you
said
didn't.
yes, you did. You did. You asked me to give them my witness
Mr.
list.
Brooks,
I gave them my witness list. It's not my fault. It's not my fault they weren't gonna be prepared to
Mr.
do
Brooks,
their
here's the
to
deal.
do
The
their
jury's
cross.
coming out, and I'm gonna stand my ground on this.
I'm gonna
If
stand my
it
ground
is-
too, but I'm
if
not
you
gonna
don't call
be
her-
disrespectful or disruptive.
If you
I'm just
don't
stating I
call
want it to be
her,
fair.
When the jury comes back out, I'm releasing her from the subpoena.
You can't do that.
For your
Where's
lack
the
of
lawful law?
cooperation.
Where's the lawful law? I have the right to
You have to
witnesses,
cooperate with this process.
but I
sir.
also have the six-minute right.
We have a witness available for you to call. I can require
It's
you
not
to
the witness
call her
that should have
right
been
now.
called at this time, Your Honor.
It is based on the list that you provided and
They didn't
in
have a
order.
time. They didn't have a time or
I'm not going
or
to play
order.
this game with you.
It's
sir.
not no game. That's
It
what
wasn't
you don't
Here we
seem to
go.
a game to
understand.
you. I believe that fully.
I don't care what you believe fully.
All right.
It's not a game.
We.
I don't take
I
this
have-
as a game. That's what
Let me
nobody.
explain this to you
That's what
once
nobody.
again.
You don't got to explain nothing to me.
Do you want?
That's what you don't understand. You think
you
that
want
this
the
is a whole
opportunity
game
to
to me.
question?
This is not a game to me, Your Honor. Nothing about this is a joke.
I never
That's
said
what
it
y'all
was a
don't
joke.
understand.
But there's
And it's
some things in the
unfair.
ship
It's
that's going on.
unfair and it's disrespectful to me that you think I would come in here purposely
And it was
treat
at
this like
that
a joke or a
moment.
game.
I never
It's
said
at
it
that
was-
moment.
What type of statement is that?
Mr.
Your life.
Right there. Right there. That's what I was trying to get back to. That right there. That. Now, see, this is why when we had conversations before and people like, no, we got to stick up our people because they black. I don't mean no harm. Y'all excuse me for 1 second. But this is the type of buffoonery that I was talking about right here. Because I'd be darned if I'm going to sit here and still, I did. No. You just happen to be a black person that's up here acting a darn donkey. And no, I ain't backing you in this mess right here. Absolutely not. Absolutely not. Boy, look at him. Look at him. This?
Is not on the line. Mine is. And you think that I think this is funny?
I don't think it's funny whatsoever.
So
And I
I
understand.
think, Your Honor, with all due respect, I think you should show
we're
some
gonna take
respect.
a 5-minute break, and when we come back, the jury.
He just told the judge to show him some respect. He told the judge to show him some respect. The man that unalived all these people. The man that injured over 60 people. The man that you can see in the vehicle and you can literally see the vehicle going up and down over people and rocking sideways when he actually drives over somebody. This man is demanding respect. He is demanding respect from the judge in the courtroom.
He's coming out, and you need to call your next witness. Thank you. We are in
No,
recess.
you're not rushing me to judgment. I don't care what you're talking about.
Now, they went to break, and what he did was a stalling tactic because the next set of witnesses were scheduled to come in at 10:30. And he didn't want to interview his ex-girlfriend early. He wanted her to be later. So he wanted the judge to wait around until some of the 10:30 witnesses came. So all this stuff that he was doing, he was holding up the court in hopes that this stuff would drag out until one of the other witnesses came and he could put them on the stand, because then Erica would have no longer been the only witness that was there. So that would just knock the judge's decision out, saying no, well, it got to be her because she's the only witness. No, if he got another witness there, he could put them on the stand. This went on, and he ended up getting her on the stand. But he showed his gluteus. I'm telling y'all, this went on for some time. Let me move this forward a little bit. It was only supposed to be a couple minutes. It was supposed to be 5 minutes. That is not what happened. Let's see.
My clerk, I didn't hear what you asked. The jury's coming in.
You heard what I asked.
I actually did not.
Come on, Your Honor. Come on now. We got to cut that out. You know you have to prove subject matter jurisdiction. You know that. You have to honor your oath of office. You know that.
Look at his face. Child.
Thank you, everyone. Please be seated.
Whew.
The defense may call its next witness, please.
Give 1 second. I'm trying to make sure I got the paperwork since I'm being rushed to judgment.
Now I want y'all to take note of how he can go from 0 to 100 real quick and then go from 100 back down to 45 within 3 seconds. Just that quick. Just that. I need to get my snapping side. Just that quick. For people that are watching that, this is not normal behavior. This is definitely not normal behavior. Let me look at some of y'all comments real quick. She's going to show him all the respect at sentencing. That's one of the things. See, whenever you have this type of stuff going on, they're not able to think things all the way through. They don't have that forward thinking. They're in the here and now. They don't see anything past that. And that's really what he need to be thinking about. It's going to be ugly in the trial. The judge said she was afraid of him. I knew, well, let me not say I knew, but I felt like that would be coming at some point to where they were like, you know what, bump any, if he appeal, he appeal. If he, whatever. Nah, I'm going to get it put on record that you're scaring me. I'm afraid. I'm very afraid. I feel threatened. Now it's on record. And you already got all these other charges sitting right here. And so when you do go to appeal, they got the judge on record and looking at your behaviors, they got the judge on record saying that she is fearful. And he did threaten her. It was an indirect threat, but he did threaten her today. Yes, after he did all that crying, I want you guys to see me for who I am. I want you to see me for who I am. Look at the real me. I'm taking the mask off. I'm taking the mask off. They see you, bro. They see you. You probably should have kept that mask on. This judge has been very, very, very nice. You got 3 berries up in there because this dude, ooh, child, let me tell you. Reckless homicide, he was probably looking at 5 to 10 years once they got done. He'll probably look at, he getting life sentences. I'm gonna give him that. He ain't getting out. His contested immediately said, "There he goes, standing right here in the courtroom, pointing him out." Mike Jones, I'm gonna show a clip because he did an interview at the court today. I'm gonna show y'all. Don't let me forget. I'm gonna show you a clip of the interview with that guy, that one witness that he had called. He did an interview at the court. Not at all, ladies in the chat. Has he had a psychiatric evaluation? He had, according to his mom, he has had like some type of mental health. Bruce, that's why I was going mask off. He's had some type of interaction, some type of mental health dealings. I don't know that he's getting anything now because I haven't heard anybody actually say that he was on any type of psychotropic meds. So I don't know if he's actually, getting any type of, medicinal treatment at this time. It would appear as though he isn't getting anything, or if he is not utilizing the tools that he has been provided to deal with his impulses. It's something weird about his eyes, like it's another entity in it. That's what I'm saying, Big Red. That's what I'm saying. If you watch his eyes, you can tell when he's about to blow. Just like the pictures from the parade, that they actually got a close shot of his face and you can see his eyes, the focus of his eyes. He was gone. He was gone. And that's the same look that he has in here when he's about to go into one of his rages. That his eyes, he has like a blank stare, like there's nothing there. There is absolutely nothing there. You see his little forehead start crinkling up, his eyes get smaller and they get big, and then they just, like it's something straight out of a movie. Like there's no feeling there at all. And that's why I asked the question the other day, is he evil? Or is it just a mental health thing? Or could it possibly be both? Let's get back into Mr. Brooks. These are some more stalling tactics. I'm going to move forward just a little bit. Now, he is going to go ahead and get prepared to have her up there, but he stalls for a minute. And I just want you to see Miss Erica.
Whoa. Pursuant to the question.
Look at how he's standing while she's up there. So this is Erica Patterson. This is his ex-girlfriend. This is the one that he actually got the statutory sexual seduction charge for, that he pled guilty for. The reason why he had to register as a sex offender, this is her. And as you can see, she still looks young up here. So some people were guessing that she was 15. When this happened. I don't know how old she was supposed to be whenever he impregnated her and she had a baby. I don't know. But we do know that the child is 15 years old now. Yeah. Moving right along. But this is Miss Erica. Excuse me. Also the one that he punched in the face with a closed fist and hit with the car.
I think that kind of got a little ahead of.
Mr. Brooks, I'll let you interrupt the answer and you can ask a follow-up. I apologize. I was instructing the clerk to turn up the volume. So go ahead, ask your question.
Same question?
Sure.
What were you doing the evening of November 21st, 2021, before linking up with the alleged defendant?
He was my roommate at the time.
So he did a couple things with this. Number one, he was trying to get her to provide some information about another friend that testified on yesterday. I think that was Kirby. That came across like one of the lost boys. He was trying to get more information on that, and he was trying to make it appear as if she perjured herself on the stand, and trying to make it like she wasn't, that good of a mom. Which I don't know, because she seemed to have some things going on. So I don't know what what that situation is with her. But that's what his goal was, and to just try to get at her, understanding that this will probably be the last time he sees her in person. Might be the last time he hear her voice at all. So he's trying to milk this up as long as he can. But as you can see, he's able to, just for a little bit, he can hold it together. But the minute something doesn't go his way, or it even appears that it's not going his way, then he shoots to not even 100, he shoots to 1,000. So I'm going to put this, fast forward this just a little bit. Girlfriend is over it. You hear me? She is over it. She's like, I am not impressed with your antics, honey.
We have you claiming that there's some document that was sent by the witness.
So let me take you back to that. So he pulled out some pictures. He put old Hail Mary up there. So he done snuck some stuff in his box. He done stuck some contraband up in his box that he ain't supposed to have in court. He done snuck some stuff up in court that wasn't supposed to be in there and caught them off guard. And he hits Erica with some pictures. Bam. If you don't talk to me and you so scared of me, then where did these pictures come from? How did I get these pictures? So this is what kicked a lot of the stuff off. So the video that I posted earlier, when you see the prosecutors dropping the bombs, this is a direct result. Well, that was a direct result of what happened with this situation right here.
So my question would be,
there go the pictures.
I don't know if you can see them from here, but do you recognize these pictures?
You need to show those to the state.
Look at that face. I didn't even notice their faces earlier. Child. They said this mofo. Please understand that I am not laughing at the fact that this situation happened. But the antics of this guy in this courtroom. He got mad if people laughed. He got mad if people smiled. He got mad if they were talking to each other at the table. He couldn't hear their conversation. He said that people are being unfair to him, that the judge is biased. Everything is corrupt about what's going on. Nobody's helping him, but then he didn't ask for help. Like, he has all these things going on. And this mofo done snuck some contraband up in the courtroom. That was not part of the box of materials that came from the public defenders, because they left him the stuff that they already had done. Bruh done snuck them things out the cell, child. He done snuck them pictures out the cell. Okay? Let me take that, because the facial expressions are priceless. Oh my goodness. We're going to take that one more time.
Reno, Nevada.
How long have you known the alleged defendant?
16 years.
Made reference to meeting in Nevada. Do you recall where you met at in Nevada?
No. I remember.
Now, see, this is an area that he needs to be staying away from, because, see, that's where he got the charges when he met her in Nevada. And he impregnated her when she was underage. That's where the charges came from. And they keep warning him to stay away from stuff. You even had times where the prosecution objected for him because he didn't realize how much of a mess he was about to get himself in. And he still... Breathe, child. Breathe.
In relation to the alleged incident on November 21st of 2021, would it be fair to say that there's been no contact between you and the alleged defendant?
Not since then, no.
That last answer was kind of low. Did you say no?
I said no, not since then.
So that would mean, assuming that would mean no contact at all via phone or anything.
That's after he cut his dreads off, Bruce. Then he cut his dreads off. Well, they cut his dreads off.
So my question would be,
here you go, the red herring. Watch the faces of the
I don't know if you can
prosecution.
see them from here, but do you recognize these pictures?
You need to show those.
Look at that. Child, that lady said, you got to be effing kidding me. That's that. I know you effing lying. That's that face. That's that face. Oh, Lord. That's that. I know this jigger did. Like, what? Child. Look at those faces, child. He got the whole people's eyebrow up here because he don't know what to do. I'm sorry. I digress. Let's move on.
To the state, the bailiff will take them. It's not proper procedure, sir.
He think he did something. Look, he think he did something. Look at him.
No relevance whatsoever to this trial.
Yes, they do. And
Sustained.
I'll get to how they have.
It's
Oh!
also never been disclosed to the state before this moment.
Sustained.
Sustain why?
Not relevant.
They are relevant. It creates foundation. And I can prove that.
I'll take up the issue outside the presence of the jury at the conclusion of this witness, and if need be, bring the witness back in. But next question, please.
And these need to be offered into evidence as well. You stated that there's been no contact. How would the alleged defendant obtain
He about to put on a show, y'all.
photographs from you if there's been no contact?
Objection.
Grounds.
Suspect, not yet.
Grounds.
Sustained.
Me either, Miss Ty.
Suspect's not evidence. Not relevant.
How's it not relevant? Photos just don't pop up out of the blue.
Mr. Brooks assumes facts not in evidence,
No,
and
it's
at
facts.
this point
I
of
got the pictures
conduct
right here.
after
Facts.
the alleged date of violation here, it's not relevant.
Alleged violation.
You're
For the record.
correct. After the date charged, the dates that are charged for these allegations, you are absolutely correct.
Thank you. Have you, since the evening of November 21st of 2021, have you attempted to contact the alleged defendant?
Objection.
Grounds.
Relevance.
Grounds.
I'm going to excuse the jury.
It's about to go down.
Think you be seated?
Your Honor, I find it.
Hold on.
Here we go. Here we go with that boo
Sir,
filet.
you can also proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You want the letter
hold
too?
on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying.
I'm gonna press pause because he had me for a minute because he was like, I'm like, okay, so she has been communicating with him, okay? Because he said, you want the letter too? Like he was about to present something, show your receipts, so he had me thinking, okay, so she's still dealing with old dude. But the plot thickens.
And then also by what's the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you speak and have contact?
Do you want to open up the door to the other act's evidence of
That's not opening.
No.
That's not opening the door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts of evidence between you and this witness.
The DVs, the running over, the
come in.
You
keep
salacious stuff.
Her about whether she's afraid or not, or
I
why she
didn't
wouldn't
question her
have
about
contact or not. You are opening the door to that testimony. All of my rulings have been made to prevent what could be seen as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial that I have a document stating that November 20th never even happened, but yet still the witness can get on the stand and lie on the stand.
Over to the state.
Come on, man. Y'all know that's not right. Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. I'm having you make an offer. When did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly that didn't even exist that I didn't have. But
that's not true. That's a misstatement of the
that is true.
No.
She said it herself.
No. Marking an exhibit is not creating an exhibit. No,
not marking an exhibit. She said
we're not going to go down a tangent, sir.
Right,
I'm going to focus on this, and I'm going to give you the opportunity to make a record.
It's not fair. It's not fair.
When did you receive this document that you claim was sent by this witness?
It's not claim. It's for a fact.
Sir, it hasn't been established yet. I need to make a record.
So
I want to see the letter. I want to see.
Give him the letter, Darrell.
And I want to know when you received it.
I gotta bring that in.
Nah, he acting like he got the letter.
This is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem. But the state can
place the letter into evidence, Darrell.
There are proper procedures, and I want you to make a record. If you don't make a record, then I can't make a ruling.
It threw people off the loop. They weren't ready for it. They shared of it. That's what it is.
Y'all, he think he did something. Now you looking like a bit of a narc here.
I respect your courtroom. I respect you. You're a public servant, though. Your job is to be the referee. Is it?
Look at her face.
You stated so yourself on record that your job is being the umpire.
Your Honor, can I ask Ms. Tyson, please be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth. Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So let me I'm going to make a record about what he's referring to in count 77. Okay.
What happened to that paper? Because it was on the table. Then when I come back in,
I need to make a record of a variety of things.
So who took my paper?
Not even stole his paper.
Repeatedly today, I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you do it repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make it a record.
Right, Mike. He made sure he had them pictures. That was his aha moment right there. He'd been waiting all his life for that moment.
That Mr. Brooks wanted to show Detective Guth and this witness was a
yes, he's acting as his own lawyer.
Wisconsin to the court regarding count 77.
I do think he needs a male
the state
judge.
sought
This
to
man
dismiss
has
that
issues with
count,
women and being
have
disrespectful.
Prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's I can't answer. It was dismissed because the request was made, sir. They don't need a reason.
Now let me tell you about the ignorance of what he's asking right now. He had an additional charge. He had additional charges that were linked to his ex-girlfriend, the young lady that just left the stand, Erica. Prosecution dropped those charges. Now he's sitting here arguing with the judge about why the prosecution dropped the charges. Are you kidding me? So you just not gonna take the give. You want them to put the charges back on you? I mean, is that what you want? You asking the judge why the prosecution dropped the charges. So she about to give him what he wants, y'all. But I just want y'all to see how just
there's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess is maybe to simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis for why the state sought dismissal of that charge prior to the start of this trial?
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
I've been trying to find it ever since I came back.
You objected to the fact that they dropped those charges. Some more battery charges when you already got pending charges. So you object. You know what?
And now all of a sudden I can't.
And now you're impugning, though, like somehow you're impugning the integrity of this court, the bailiffs of this state. You're accusing, frankly, everyone of moving your paper.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly.
Right, Big Red.
You did,
so how can you make the assumption that I'm saying?
Can I please make the record without being interrupted?
Yes, you may. Yes, you may. I apologize.
I appreciate that. Thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out,
74 Rashida, he sure is.
You even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone touched my table? I didn't
You
say
implied it, sir.
But did I say that?
You stated it implicitly.
I never asked the bailiff, hey, did anyone touch my table? I never said that to them. I just said, I can't find my paper, which is the truth.
And the way that you said it, like,
I didn't point anyone out, though.
And like, well, that's kind of interesting. I don't have a document that was just on my table. That is what you said.
That's what I said, but I did not point the finger at anyone.
So,
I
you
can see
have
if
the
I
letter.
came in, Your Honor, with
You've
all
been
respect,
given.
I can see if I came in and said, hey, when did you move something off my table? Or if I would have directed that towards the state, or if I directed that towards the clerk or something like that, then it would be that would be more validity to what you're saying.
I need to continue with the record, sir. It's very apparent to me, sir, that every time, I can't say every time.
Don't say every time. Don't say every time.
Many times throughout this trial, and especially the last 2 days, when the court makes a ruling that you disagree with, or I want to make a record about some behavior of yours, or a further record about a ruling that you that was not in your favor, that you start peppering me with questions or comments, statements. You question me about the law. You ask, is it verified law? It is, from my perspective, a clear attempt to kind of turn us in a direction away from what we're doing, perhaps even to stall and to delay.
Distraction.
That's my perspective. That I'm making a rule. You're doing it again.
I mean, because it has no validity.
So, I am trying to make a record,
not the
outside
validity,
the presence of the jury, about a line of questioning you want to ask Ms. Patterson. Now, I've reviewed repeatedly up on the bench 90608 and 90616, which are two of the primary ways you can attack credibility. I've referenced one of those previously. 90608 is evidence of character and conduct of a witness. I'm not going to read through it all, but it's limited to character for truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness who's testifying. All right, then there's the statute on bias, 90616. All right, and none of the questions, as I heard them, went to a permissible topic under bias of witnesses. You generally said credibility. You did not give me any further explanation as to why you believed it was relevant to credibility. Now we have you claiming that there's some document that was sent by the witness after the charges were filed that apparently contained photographs.
What a document, Cletus.
And you can clarify the record momentarily when I'm done. That you believe goes to the credibility of this witness. So I need to ask a few questions about that, sir, to determine whether it has relevance to those issues. Number one, when did you receive this letter?
I received this multiple letters, actually, over a period of time. It wasn't. I referred to this one because this one had the pictures. But
and why do you believe it was from Ms. Patterson?
Okay, let me turn on my human lie detector test for a minute. The shifting of the eyes when answering the questions, the lie detector test determined that that was a lie.
The question with clarity.
Thank you. Does it have a date on it? The letter?
No, I didn't bring the letter. I brought the pictures because I thought from.
Number two, another lie detected by the human lie detector test. He just acted like he had the letter in his filings. He asked if they wanted the letter. Now he's going to go and say that he does not have the letter and watch him give an explanation for why he doesn't have the letter. This exposes him for another lie while he's trying to discredit the witness.
My interpretation, I thought showing the pictures would be okay. How did I get these? So my mind was saying, show the pictures. They didn't come out of thin air. The witness knows that they sent me the pictures. They know that.
Well, again, it assumes facts that aren't here. You're assuming this witness sent it. I don't know. But even if she did, what relevance does it have to her credibility?
One of the main questions that she asked this man that she was trying to get him to give her an answer for that would make all the stuff that he's saying valid. He could not answer one simple question. And I want y'all to catch it. And the lie detector test determines that this whole thing with these pictures in this letter is a farce, okay? That it's all a lie. And I will go back and let you know which question he should have been able to answer just by saying three simple words. Let's see. 5 simple words
for this jury.
It goes to the credibility because she's put on this facade of being
Not
so
the facade.
afraid of someone, but yet still, you know that we're not supposed to have contact, but you still sneaking behind and saying, "Oh, I wonder how you're doing," and oh, this and this and that. Oh,
I don't think
no, I
she's
still
ever
love
said
you.
she was
Oh,
afraid. I
ooh,
think that was the officers who may have stated that, but I don't believe she
But-
ever said that. She specifically said today when you asked her why did you, it was either why did you go back or why did you have, I'll look at my notes, and she
It was
said, I don't
why.
know.
It was why weren't you forthright with all the details?
Right, Angela. Anybody could have sent it.
So again, I'm going to ask you, even if this letter's from her, these pictures are from her, how does it
Your
relate
Honor.
to her credibility before the
Who
jury?
else could it be? Who else could these pictures be from?
I'm going to ask you point blank.
Okay, this lets you know that he's lying here too, okay? These are the facial expressions and the mannerisms of a narcissist that is trying to convince someone. This is some of the gaslighting stuff right here that you are seeing. Just the fact, that frame right there, just that frame of his face right there, it tells a whole story. It paints a picture all by itself. I'm just saying. But just watching his mannerisms in this particular point, and this leads to the big blow up that is coming. But again, he cannot answer a simple question. How do you know that the letters are from Erica? How can you prove that they are from Erica?
Like, did you get a letter that's signed from her?
I got. What do you mean sign? No
How
one
do you know?
signs letters.
What's your belief? Why do you have a belief that they are from her?
I have multiple letters from
You're
her.
not answering my question.
Why didn't you bring them, Cletus?
Why do you believe the letters are from Erica Patterson?
Because they were sent from Erica Patterson. Why else would I?
Were they signed by her?
What do you mean signed?
Did she write her name on the letter? Was
Are
it the
you
content of the
kidding me?
letter? No, I'm not kidding you. I need to make a record, sir. You're making a statement that these letters are from her and that they're relevant to her credibility.
Your Honor, I'm gonna go out on a limb.
Don't go on that limb, boy. Don't go on that
I'm
limb.
gonna go out on a limb.
You're going to fall off. You don't want it.
Which I know is true. You've never been in my position. You've never been in jail. So you've never received a letter from someone writing someone in jail.
Oh, he think you're making a point now.
When you
You're
say
not
to me,
answering my
when you say
question,
to me,
sir. What's the basis why you believe they're from Miss Patterson? Is there some information in them that only she would know? Did she sign the letters? Is it penmanship that you recognize? Why do you believe they're from her as opposed to somebody else sending you information? It could be your mom, it could be, I'm just saying, it
why
could
would
be anybody else.
somebody? This is,
You gotta answer my question. It's called
Your
an
Honor,
offer of
this-
proof.
but you still gotta understand why this is mind-boggling.
Not mind-boggling. He is
I had a child
flabbergasted.
with this woman. Why would I not know her handwriting?
But you have to
Why would
lay a
I not know?
foundation for these letters, sir. That might be
This
through
is
your own
ridiculous.
testimony. So that I'm trying to figure out why you believe they're from her. Not all this other stuff
Are
about
you
I'm in jail
serious?
and I have a child.
Let me press pause on this. Let me poll y'all. What would be the main thing that he could say or could show the judge to prove that the letter came from her? Or to show, not prove, but to show that even if somebody else sent it, that she was the one that it supposedly came from. What is the one thing that he could show the court? He got all this sense. And the judge playing with him. She dancing all in the circle because she know he can't produce what he claiming he has. The one thing that he can produce, the actual letters. What about the envelope? Yeah. It needs to have a going and a coming and a going address on that envelope. What about the envelope? Yes, Bird, the darn envelope. You don't even got to show the letter. Maybe it got some, some stuff in there you don't want us to see. Show the judge the envelope, bro. That's all you gotta do. Just show the envelope. But he too smart for that.
called an offer of proof.
Are you serious?
Are you serious, Darrell?
Why do you believe they're from her? I am serious.
Because they're from her.
But you're assuming.
Like how else am I supposed to answer that?
I've given you a few reasons why it would lend to that opinion.
So it has to be put in a legal
The
term.
bottom line is I need the letter. So if you're gonna question her on that, the state absolutely has a right to see the letter. So you need to provide that letter. The bottom line is I'm not gonna allow any questioning without having that letter. The state has the ability to question.
Spoiler alert, spoiler alert. The reason why she's giving him a hard time on this is because the prosecution knows that they heard a conversation with him and talking to his mama on the phone, and he was asking for his mama to send the darn pictures. Spoiler alert, spoiler alert. I'm sorry, y'all. Don't curse me out. I had to say it.
Question you about that, or question this witness, and to look at the veracity of what your claims are here. So when I may take an early lunch. If that's in your cell, then you can go get it and bring it. But without that letter, I'm not allowing this line of questioning. Do you have the letter with you in court?
I just said no. How many times I gotta say the same thing on record?
You know, sometimes, sir, I don't hear what you say because you interrupt me so much, or you answer quietly. And I'm taking notes, and I'm focused on probably a dozen things at the same time.
But if I say something under my breath, everybody seems to hear it. Everybody seems to hear
that
just fine.
In a quiet courtroom, yes, we can hear it very clearly.
Everybody assumes that it has to be disparaging.
Once again, you're doing this tactic.
Because it's not a tactic, it's facts. It's facts.
To some other reason.
It's facts. Because I find it hard to believe that
I'm
all
gonna
of a sudden nobody hears what I say.
I'm going to let the state make a record of why they believe it's objectionable, because I haven't let them do that. I've given you multiple opportunities to tell me.
And the bombshell is coming.
Nobody else. Why was somebody
The record will
else
reflect you have two pictures that you believe were from this witness.
that I know is from?
No, that you believe.
That I know.
All right. I'll ask the state their position on all of this.
In 5.
Your Honor, is that these pictures, first of all, should not be admissible. One, because of a discovery violation. We've never seen them before.
He's talking a little low.
There's reason to believe that he did not get them from Erica Patterson. He is on a jail phone call talking to his mother, Dawn Woods, about Dawn Woods sending these photographs to him. Now,
That's a lie. I object to
Let the
that.
state make their argument without interruption, sir.
That's a lie.
Uh-oh.
3, I believe that these photographs are designed to make a suggestion to the jury that Erica Patterson is a bad mom. I think that is what the defendant is trying to do. And if we're going to go down that road, then we would be forced to counter that claim. First of all,
Here you go.
An incredible witness, if it's even true. And second of all, if we go down that road, we would be forced to counter that claim by pointing out that not only does the defendant not live with the child in question, he doesn't live with any of the other children that he has. He impregnated Erica Patterson when she was a minor in Nevada, and for doing so, he was convicted of statutory sexual seduction, pled guilty in March of 2007 to that felony offense, and is a sex offender on the registry as a result. So if there's any causation that would lead to Erica Patterson being a bad mom, Mr. Brooks has a direct role in that causation.
And that's
Furthermore,
object to that.
I'm not
Because
done.
that's a lie.
I'm not done.
Let him finish.
If we don't open the door on that, no, since he want to make a record and not be accurate, so let's be accurate all on the record since you think you know so much.
Okay.
Once
So
again,
we can
Mr.
open the
Brooks
door
is
on.
being
We can open the door on how old she told me she was when we met.
interrupting.
We can ask that question
He is
too. Then
over the
Did you
top
ask that?
animated
Do you
right
know
now.
that?
Mr. Brooks, I'm ordering you to sit down and to let the state
No, that's
finish.
hard. I'm not going to sit here and let somebody be inaccurate on the record and lie on the record.
Right. Under Illinois versus Allen, I've warned him repeatedly. He's being removed from the courtroom. And you know what? Let me dial that back.
Dial it back.
Early lunch, 1 hour. We'll be back. And unless he brings that letter, then he can show it is inadmissible. He will not be questioned. And under 906.11, I will declare the cross-examination closed. Thank you. We're in recess. 1 hour.
Get your facts straight. So let's open the door on all of it again so we can get all of it on the record. Since you think you know so much. Did you know she said she was 18 when I met her? Did you know that?
Oh, Darrell. So what y'all think? What y'all think? Y'all, all this happened before lunch. They went to lunch a whole hour early. Okay? All this happened before lunch. Okay? Before lunch. This was just the start of the day. Now, what I'm going to do is to see if I can get the video from yesterday. Okay? Because I want you guys to see his opening argument from yesterday. And let me stop this screen on here for a second for y'all to get his opening argument from yesterday, because he never gave his opening argument. So at the very beginning, so he did everything yesterday. And he's, going and basically throwing himself, on the mercy of the court, of the mercy of the jury, asking them to see him as a real person, to really look at him, mask off. You know what I'm saying? Like, really, look at me. He just had this whole dramatic moment, and everybody's making him out to look like this bad person, and child.
We'll address certain things.
Hold on.
To 400.
Thing from a legal basis for which I.
Okay.
Expects the evidence will show so that.
So let's go back into this. So I'm going to give you guys his opening statement from yesterday. And let's compare this to the actions that we saw today. Yes, he is completely exhausting. Even though we are not in this courtroom, I don't know about y'all, but I can feel the frustration coming from everybody in that courtroom, okay? Because this, I'm going to show that, Angie. Don't let me forget. Okay, so this was, and this is how you know that there are some real issues there, that there is some there. Y'all, okay, let me just, because I see, was that Big Red has to ask about whether or not she cried. I didn't see her crying, but I saw somebody in the comments was like, is she crying? I didn't get to see that unless she like wiped her tear or wiped her eye or something like real quick. But I'm like, you know what? You just doing too much. You doing, and I mean, you can feel a little something, like, okay, woo, you had a hard time, and then you come back with the buffoonery. I mean, child. Okay, let's get back, because you guys need to see this from yesterday. Like I said, it has been a full week, honeys. It's been a full week. So this is the judge finishing up reading her thing before he goes to present his case, and we'll start here.
They will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. With that, go ahead, sir.
Obviously, I don't have any rehearsal well prepared speech, so I'm just going to speak from the heart. I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember, is that there's always two sides to every story. And for so long now, roughly a year, there's only truly been one side told of this story. And I've sat back and watched from countless narratives that's been put out there, the way this incident has been portrayed at times, and finally, everyone getting a chance to get the full story. You won't hear me try to argue facts. The fact is that this incident was tragic, very tragic. That's not lost on me. Facts are that there's still a lot of people healing, a lot of families healing, on both sides. And when I'm confident that the evidence will show, sorry, I'm getting a little emotional. When I'm confident that the evidence will show is that this incident was not planned. This incident was not intentional. This incident was never even thought about. It's easy to I'm sorry. Just wait a second. I think it's easy to look at the magnitude of something like this and form opinions. I think it's easy to disregard a lot of factors. And I think in reference to what I stated earlier, it's easy to forget the other side of the coin. There's been a lot of suffering involved in this incident, a lot. Obviously, with the families, with the community, and even the alleged defendant's family as well. There's been a lot of suffering. A lot of misunderstanding. And I just want you to keep in mind everything that will be presented in its totality keep in mind. The power that you have. I believe that should escape your knowledge. This has been a long process for everybody. And what I believe is when it's time for you to make your decision, all of you, I believe that, and I pray that it's the right decision. That all the factors are weighed. There's been a lot of words thrown out there about the alleged. A lot of speculation, a lot of ridicule. Words like demon. Words like monster. I know a lot of the time I've been before you, you see me with this mask on. I've had my reasons for that. But I feel now is the time that it's important that you see me for who I am. No mask. For who I am. I think this is the moment for that. I pray that your eyes and ears remain as open as possible. And understand that you alone decide this case, this matter. power is in your hands. All of you. To determine for yourselves what truth is. Thank you.
Thank you, sir. And do we have their writing materials available? All right. Thank you. Mr. Brooks, you ready to call your first, would be your second witness, actually. You need a minute? Take a short break. I'll rise for the jury, please. We'll be with you shortly.
Now, unless I missed something, I don't recall seeing a judge crying.
The materials that you were looking for, let us know if there's something you need in that regard. And Attorney Apper, if you could perhaps just confer with him over which witnesses are here. I'll step off the bench while you do that, and then someone can just let me know. I'll come back out in like between 5 and 10 minutes unless I'm told to come back out sooner.
Yes, sir.
Thank you.
So that was his opening on yesterday. That's how he started with his presentation. So he wanted the jury to look at him a certain way, to not see him as this monster, this demon that people are talking about. And even before this day was over, within them coming back from break, and he had his little moment where he was able to control himself because he was still trying to pull it all together. But even in the midst of that, it's still you're having difficulty controlling those impulsive behaviors. Now I am going to go back to the video from today, and I can show you clips from clips from every day, because it was something every day. It was something literally every day. Let's see which one this is. Like, there was some mess with him every day. So what I'm gonna do is skip to the end on this one so that you guys can see the stare down that we've been actually, let me get to, before I even get there, I'm going to show you a clip of one of his witnesses that he had come up there, because this guy did an interview at the court today. So I'm going to show you just a bit of this so you'll understand the guy's responses during the interview that he had with the news today.
Do you recall stating that? Well, let me back up for a minute. Did you speak with another detective?
Right, Bruce.
Did you recall?
Yes, I did.
Do you recall if that was Detective Coates?
I don't remember his name.
So it'd be fair to say that you spoke with two different law enforcement officers that evening. Do you recall in your interview with Detective Coates, in reference to the vehicle that you saw that evening, do you recall telling Detective Coates that it appeared there were 3 or 4 people in the Ford Escape as it passed you?
No, I don't remember that.
Do you recall in your interview with Detective Coates that evening stating that you could not provide any description of the occupants other than that they appeared to be African American?
Yeah, I remember saying that.
So it'd be fair to say that you observed African Americans in this vehicle that you saw, correct?
The reason why I came up with 3 or 4 people was because when I was walking by and I saw the car, there was 2 or 3 black males standing by the vehicle. There was at least 3 or 4 more on the porch. So I figured they were by the vehicle. It must have been the ones trying to hide the vehicle because they were standing in front of it or real close to it.
All right, so I'm going to pause that right there. So this was one of his witnesses that he called up today. This guy was just at the parade with his family. He was just just an innocent person. He wasn't in the parade. He was just there to watch the parade. So I'm going to jump really quick to the interview that he did after court about having to testify for the defense on today.
Question is, what is it like being called as a witness for the defense in this case?
I don't know. I was surprised, I guess. The state had called me first, and then they canceled my subpoena. And then the week after that, this guy subpoenaed me. So yeah, I was surprised.
Did you think that there was anything that you could offer Brooks in terms of a defense?
No, not at all. I don't see why he would think I would help him out.
So you saw where that red SUV ended up, correct?
Yeah, I walked into we were leaving the parade, and I was just watching everywhere because I just thought there was more cars. I didn't think it was just one person. I figured this has got to be something big. I didn't think somebody could do something like that. But so I was just keeping an eye out because I had my 8-year-old daughter and my wife with me, so I was worried for their safety. But yeah, I was looking and everybody was walking by, and I guess just a couple of people that were standing out there in front of the vehicle just got my attention because everybody else was running and these guys were just standing there. So I looked over and I noticed the vehicle, and then that was it. I told my wife, I gave her the key, and I told her, get home as soon as you can, call 911. I'm going to run back in there to the parade and let the authorities know.
Over the last 11 months, have you kind of realized how instrumental that was to this case?
I don't want to sound funny or anything, but I really haven't been paying attention to any of that stuff. But until my wife was watching it, and she had mentioned that Officer Moss had mentioned my name, they put it out there, and then that's when I started paying attention to it.
When you were on the witness stand, did you feel like Darrell Brooks was prepared to ask you questions?
No, I didn't think so.
You were just winging it?
I think he was just trying to get something, trying to get me to twist some words or whatever. I don't know why he would have me up there in the first place.
And have you formed an opinion about his innocence or guilt?
Oh no, of course he's guilty. I mean, I saw him. I mean, it happened right in front of us. I mean, the vehicle was the right vehicle, and it's just, I don't know.
Okay,
No
so
doubt in your mind that
what I'm gonna do, because what I didn't show before is I do have a couple of clips, and YouTube probably gonna hit me for these clips. But for the people that are not aware of what happened, see if I still have them. Well, I'm trying to find one that's not, I don't want to show. Okay, I'm not going to show those. But I will show you a clip from yesterday of the prosecutor finally talking to the judge like, listen, we got to do something with this. The DA, she's like, enough is enough, you know? If I can get it.
On instruction. Thank you, everyone. Please be seated. The defendant will now make on instruction. Thank you, everyone.
Hold on. That is not the right one.
Thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well aware. There's nothing that.
Hold on, sir. Stop interrupting. We have to make a record of it. You've interrupted multiple times. I've been abundantly patient with you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at me. Stop rolling your eyes at me. Stop mumbling.
I'm looking right at you. I'm not rolling my eyes.
No, you have throughout. I've seen it and I made note of it.
I'm looking at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Go ahead, Attorney Amber.
Thank you, Your Honor. And just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court that need to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor. And we appreciate that. He is not in control of this courtroom. You are. And he needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did because he pushed it again, and his voice and his mannerism of speech, I thought would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up. And whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing in law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks because, again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception. I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because.
So as you all can see, this has been a mess from the beginning. And like I said, this is what, week 3, 2, 3. It's just been a mess. It has been a mess. Everybody's scratching their head. Look, got me scratching my head now, child. It has been a mess. We dealing with all kind of stuff. There's so many different dynamics, like right now, so much going on that it's really hard to keep up with for the people that are watching. And I think for Mr. Brooks as well, he's having a hard time trying to keep up with everything that he has going on. I am going to go back. I guess I can show you guys this one more situation that happened on yesterday.
Can't keep doing stuff without. Should be a fair trial. That's my right. Should be able to do things without my knowledge and pass it off to the jury like that's fair. They deserve to know that too.
have a seat as well. As soon as the jury
He's working himself up. Nobody's talking to him. He's working himself up. Look at his eyes.
Right, Mr. Brooks, you are well aware that the reason
consent to being
documents
called that
are
name.
being put on
I don't consent to being
stand
called that name.
are because this court indicated it would limit the movement of the parties due to your custodial status to keep things fair.
And I
You are
merely asked, how did
attempting-
it get there?
Sir, do not
I'm not
interrupt
entitled-
me or you will
I'm not
forfeit your
entitled
right
to
to be
know how it got
present in
there?
this courtroom.
So
Do
you
not
holding me in
interrupt
contempt?
me.
Are you holding me in contempt?
Stop talking.
I'm gonna make a record.
Are you holding me in contempt?
I'm not answering your questions.
So then you're not holding me in contempt.
Do not interrupt me again or you will go to the other courtroom.
Under what lawful law?
All right, he's interrupted me once again. We're gonna clear the courtroom. He's being disrespectful. I'll make a record once he moves. Unless you can promise me right now that you let me make my record without you interrupting me, sir.
You gonna make your record? You can make your record.
Then please don't interrupt me.
Don't hold me in contempt.
I've never said any such thing.
Removing me from the courtroom, Your Honor, is essentially holding me in contempt.
All right, no, you're forfeiting your right to be present under Illinois versus Allen.
I didn't forfeit
I'm
anything.
gonna start talking, and if he interrupts, then I will close this courtroom and he will be taken to the next courtroom. Mr. Brooks, you are well aware that the court made some pretrial rulings related to whether there would be, they can stay in, I haven't closed it yet, he's not interrupting me, whether the parties could approach the witness stand. And I did that because you're in custody and I'm not gonna allow you to approach the witness stand while in custody. That is why various precautions have taken place to limit, frankly, that from happening. Throughout this trial, there was one instance at the very beginning of the case where I allowed the state to approach a witness. I corrected that. That hasn't happened since. We've had bailiffs take items up to the witness stand, or the items have been given to the witnesses, or they've been placed on the witness stand. That's proper. There's nothing wrong about that. Nobody's trying to pull a fast one over you. No one is doing something that's not permitted by this court, or frankly under the rules of decorum and courtesy or the presentation of evidence in this case. Frankly, from my perspective, sir, your attempts and your comments are to try to dig in at this jury and to somehow create doubt about the presentation of this case or the fairness of these proceedings without the party, meaning the state, having an opportunity to refute, explain, or correct it. I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection that I will take as a disrupting interruption meant to disrupt the proceedings. I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to
I'm going to put this up just a little bit.
215 about the monitoring and irony of it all at 320. Patient with you. I've, again, as I stated earlier, I've even limited how I tell these things to the jury about how to disregard, and I simply say the jury to disregard comments and statements made by the parties or the lawyers, as those are not evidence. So I'm warning you, do not interrupt again. If this jury comes back or when they come back and you do that, then you will be removed and you will forfeit your right to be present for the examination of this witness. Let's bring the jury back in.
You might as well remove me because what you're doing is not fair. I can't even rebut what you're saying. I didn't interrupt you. I let you make your incorrect record.
Mr. Brooks, I'm bringing the jury out and we're continuing. We're going to get through these witnesses.
And I'm not stopping you from
Through your
doing that.
behavior, you're not going to delay these proceedings.
I'm not trying to delay the proceedings, so I wish you would stop being incorrect on the record and saying what I'm trying to do if you don't know that. You don't know what I'm trying to
I'm
do.
the jury out. I'm not going to argue with you.
Then don't. Because I'm not arguing with you either. I'm stating facts.
You're raising your voice. It's
because I'm tired of you always making a record. You're making a record of me trying to look bad. I know what you're trying to do. It's not gonna work.
I'm making a record of what's accurate.
You sure about that?
You're making a record of incorrect statements. That's what you're doing. You're not making a record of not being.
I'm advising you to be quiet because the jury's coming back out.
You're advising me to be quiet. Is you telling me to be quiet?
To be respectful when the
jury. Are you telling me to be quiet, or are you asking me?
I'm asking you and advising
you.
you.
Thank you for correcting that, because don't nobody tell me what to do. I don't tell nobody else what to do.
I'd appreciate
we're all adults in here. I've never told you to do anything at all.
Ooh. Sir, I'd appreciate if your tone of
the
voice.
Pressure.
I would appreciate if you would ask me.
Ooh.
I'm a grown man with grown kids. Ain't nobody gonna talk to me like that. Nobody. I don't have a problem with doing what you ask me to do, not tell me. Just like when I asked you about subject matter jurisdiction that you have yet to prove on the record. But somehow I'm being intentionally disruptive. Come on, man. Stop. Just stop it.
Jury's coming out.
All right for the jury.
Not gonna work.
Now he about to put on for the jury.
I'm supposed to be scared of getting removed or something.
I don't know if y'all can tell, but he's actually shaking. If you look at his body closely, he's shaking. Rage is all in his eyes. It's in his body. You can see it.
Examination of this witness. I believe we're on exhibit 117.
That's the glare at the judge.
Madam Clerk, would you please turn the display back on?
Look at how he's looking at the judge.
Mr. Johnson, were there other items on the front passenger seat besides the blue winter hat?
Objection leading.
Overruled. The witness may answer.
That was the same stare that he had in the car whenever he ran over those people. That was that same stare that he had. Sitting up here in the courtroom with the cameras, it's like he's completely oblivious to everything that's going on. His situational awareness right now is like zero. Oh my gosh. Right, Lady Diva, nobody can say that she tried to do him wrong in any kind of way because she has honestly gone above and beyond. And if anybody says that she tried to do any less than that, then they just want to have some mess to say because, child, my. She has definitely gone above and beyond. She's done way more than I would ever do. And I done worked with some. She has done way more. I'm pretty sure, Bruce, I agree with you on that. It's probably one of her toughest cases, if not the toughest, one of her toughest ones. Because, I mean, you got situations like this and people handle you a certain way because they know that you have to remain professional in these situations. So they'll come at you like that because they know that you have a certain degree of integrity that you must maintain in these situations. So they'll come just like with this. He knows that they don't want, the an appeal to be dealing with an appeal based on the judge's behavior or the judge's responses to anything that he's doing. So that's why they're being extra careful. I'm just going to show you guys the screen really quick because this is another one of the times where this is from today where he is glaring, trying to stare the judge down and intimidate the judge today. So this is another situation from today.
Owner visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any.
And mind you, court is over for the day. At this point, court is over, and he's stewing right now. This is going to be the last clip I'll show you guys tonight.
Radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information.
Why is he staring at the judge like that?
Information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics applications or tools with communication capabilities, to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers.
Right, Angela.
To decide the case solely on the evidence offered and received at trial. I'll have the jurors report on Monday at 9 a.m. Thank you. You are excused. Please rise for the jury.
Look at her face. She is beat.
Call yourself a judge as much. Why you should put it here? Don't even tell the jury the truth. Got no integrity whatsoever.
Mind you, the jury is still in there.
None.
Thank you, everyone. Please be seated.
Now he gonna protest by standing up.
I would like an update on whether Mr. Brooks filled out a subpoena for Dawn Woods.
Dawn Woods is his mom.
Has that been done?
No, we haven't received anything, Your Honor, and obviously she can appear here voluntarily if Mr. Brooks wants to arrange that. I don't believe a subpoena is necessary. We had subpoenaed her, and she was under state subpoena. So I know that at least some point she had notice, but our position would be, Your Honor, that we will not be responsible in any fashion for producing Miss Woods. Mr. Brooks talks to her on a daily basis. If he wants her here, he can produce her on Mondays.
Yeah, they ain't got to worry about that.
So I just wanted to know, because I know subpoena form was filled out.
If
So
I want her to be here, she's going to be here.
I agree with
So
the state
just know that.
She could certainly appear.
There ain't even got to be no arrangement. All I got to say is come. She's going to come. That simple.
Mr. Brooks, do you intend to call her as a witness? Because I'm directing you to have her
We
here
said
at 9 a.m.
all that at the beginning, man. Like, I don't even want to be in here that much longer. Just do what you got to do so I can get up out of here. I'm tired of being in the courtroom that has no integrity whatsoever. How can you even call yourself a
Mr. Brooks,
judge?
I need to make a record of
I
some
need to
things.
make a record too.
You don't
When
need
am
to-
I going to get the chance to do that?
All right, I need to make a record. He's being removed to the other courtroom. He is yelling at me. He's not going to let me make a statement. or make the record that I need to make. He hasn't sat down for the better part of 2 hours.
All you want. You can hold me in contempt all you want.
I'm not holding you in contempt.
It's criminal or civil. So I can hit you with you.
I need to clear the courtroom because I do need
I'm
to
gonna give you what you know is coming.
I need him to go to the other
That's a
side
threat.
because I do need to put some things on the record. The record should
Where's the
reflect
contract between you and I?
that Mr. Brooks
If it's
is
criminal,
yelling at
what
me.
is the crime?
He is.
Who makes the claim? And what
He
is
is. I will make the record when we get back. I will step off, but Mr. Brooks, you're being
It ain't
taken
no
to the next
Mr.
courtroom.
Brooks. Don't try to address me
Thank
like
you.
that, like we cool. You don't have no integrity. How can you even call yourself a judge? Making typing agreements, being biased, judicial misconduct, trying to steal somebody's system.
Guys, court was technically over, and he's still going. They got to put him in the other room, and the judge has to continue on.
Correct. It was very apparent to this court, and I think to anyone who was watching, that Mr. Brooks was not pleased with the witness's answers and would roll his eyes at her, or just to himself, I guess, and purse his lips.
Okay, so this is him in the other room again. So this is the other courtroom that they have put him in. You guys see he's in there reading the Bible now. But they have put him in the other room, and the judge is explaining, he can hear her, explaining to all of them why she removed him from the room and what's supposed to happen. You know, this is like they're kind of like a debriefing for the day and what's going to happen on Monday. This is what she's doing now.
Other gestures that he did, that it was apparent to this court, he did not like her testimony. And
Of
again,
his
I remind
witnesses.
everyone that it was his witness. And he had the police reports for this witness, and obviously was fully aware of her statements to the investigators in this case. So I just wanted to make a record of that. It's in part why at the very end, and given the history of today and his conduct and being removed previously, I thought it important that the court remove him at the end of the hearing.
She probably need a couple of them,
so I
Bruce.
can get through a couple of things. We have gotten through the witnesses for which Mr. Brooks issued subpoenas that the state assisted with. I did provide permission to him earlier today, if he so chooses, to call Dawn Woods as a witness. The only other witness at this point that I can identify that's been, for which the court and the state has been put on notice, of course, would be Mr. Brooks himself. I'm not looking for an answer today, but what I wanted to put on the record and what I will put on the record are certain advisements that he can certainly contemplate over the weekend, so that when I do the colloquy with him on Monday morning, he's had a sufficient opportunity to think about his decision to testify or not to testify. The advisements that I will give Mr. Brooks at the moment are as follows. Mr. Brooks has a constitutional right to testify. If he chooses to testify, I'm further advising him that the state has the right to ask questions of him, what is referred to as cross-examination. That may include reference to whether he's been convicted of crimes in the past. I still need to make a ruling on that, and I will do that first thing Monday morning. I will also advise him that he has a constitutional right not to testify, and that a decision not to testify, that a jury will be so instructed, not for that, they will be instructed that that cannot be used against him in any way, and there's an appropriate jury instruction on that. If he chooses to testify, the other jury instruction that is typically read simply advises the jury to assess credibility no differently than how they would assess the credibility of any other witness. There's the added paragraph to jury instruction 300. I would further advise him that it is his decision and his decision alone on whether to testify. I will ask him whether anyone has made any threats to influence his decision on whether or not to testify. I will ask him whether anyone has made any promises to him to influence his decision to testify. I will rely upon upon the record, specifically the record made during the waiver of attorney regarding his education. I will ask him whether he's had any medication, alcohol, or drugs within the last 24 hours prior to the colloquy. And I may also confirm that he's able to read, write English. Again, I may also refer back to the colloquy I had during the waiver of attorney hearings. I will then ask him whether he's made a decision, and then ask what that decision is. And then based upon his decision, I, of course, will make an appropriate finding. Given how this trial has progressed and the disruptions and some of the issues with, consent or lack of consent or that Mr. Brooks sometimes raises, I'm also going to advise him today that failure to answer the question, what is your decision? A failure to answer, this court will interpret as a no, meaning he will be choosing not to testify, and the jury will be so instructed. And I may ask that question more than once, depending on the circumstances. I'm also going to direct the parties to some cases that I think may become relevant about potential testimony, the scope of it. Chambers versus Mississippi. It's a U.S. Supreme Court case from 1970.
I'm going to move this up a little bit because even after all of this, if I'm not mistaken, she gives him another chance to speak.
Only the framework that I intend to follow.
What's going on, Sister?
Any questions about any of that from the state?
Nothing about any of that, Your Honor.
Anything you think I need to address before I turn to Mr. Brooks?
We do have two things to clear a record about.
Go ahead. Yep.
The first is for the testimony of two different witnesses. We provided Mr. Brooks with summaries of those witnesses' statements as recorded in the police reports. First was Deanna Aldrich. That included a piece of paper containing 3 paragraphs, which summarized Ms. Aldrich's statement to the Waukesha County Sheriff's Department.
Mano, what's good? How you doing?
Supplement number 55 under an incident report number of W21087731. The second of those was a 1-paragraph summary of the statement provided by Jason Hayes to the City of Waukesha Police Department, memorialized in supplement number 28 under incident report number 21047-493. These were, again, documents that were provided to Mr. Brooks in the discovery process, but we sought to be helpful in his presentation of evidence here at the trial today. The second issue,
once again, they helped him.
That we'd like to make a record about relates to the testimony of Erica Patterson. So for the record, I think it's important to note that the 2 photographs the defendant attempted to show that
listen, y'all.
Presumably put into evidence depicted what I believe to be the defendant and Ms. Patterson's 15-year-old daughter, as well as their new grandchild, the daughter's child, who was born around May 1st of 2022. I think that there was ample grounds for the court to end Ms. Patterson's testimony when it did, but for just in case that becomes an issue going forward, I'll make an offer of proof that Ms. Patterson, if asked about those pictures, would have testified that she did not provide them to Mr. Brooks. She provided them to a person named Michelle, who I believe is a mutual friend, who in turn provided them to John Woods, the defendant's mother. Long day. Who then, that was the person who provided them to Mr. Brooks. If she were forced to answer questions about this supposed letter that Mr. Brooks was claiming to exist, She would have testified that she has not written a letter to Mr. Brooks since he came into our jail on November 22nd. She didn't write one on November 21st either. At any point between his being taken into custody and today. It's my understanding that he has tried to call her from the Waukesha County Jail on 37 occasions.
37.
She has never accepted a single one of those phone calls. And finally, during the early lunch break, I was informed by the bailiff staff that the defendant was twice offered to go to his cell to retrieve that letter that he talked about. He declined both times.
Thank you. I appreciate the record being made. I will now unmute Mr.
Y'all know Darrell don't like the truth now.
There's anything he needs to make a record of at this point on the topics that have been raised.
See, you gonna shackle before, but you shackle now. They need to throw a lockbox on there too. Go ahead, throw that lockbox on there.
So, anything you wish to address before we break for the day?
Yeah, I can. I wasn't really hearing everything that was just said good, but why haven't I been given the chance to offer all my filings and the evidence when I already stated that before? I would like all my filings. I would like every single filing that I filed placed into evidence. Every last one of them. That has yet to be done. I put you on notice and I stated it on the record. Even before I even had a chance to start calling witnesses and put on a defense that I haven't even been adequately been able to do.
Now you ain't lying about that.
So this is something that's been stated on the record numerous times. I did hear a reference to whatever he was just talking about. Whatever he was just talking about is in regards to me going to get the letter or whatever the case may be. First of all, it's not just one letter. Like I stated before, it's multiple letters. And for somebody that don't even know to try to tell me what I got, like you need to cut it out, man. Y'all need to cut it out. Seriously. Stop it. It seems to me that all y'all been wanting to do is gang up. Be biased, be prejudiced, and gang up.
Help us, Jesus.
You sit up there earlier, made a record before the lunch. You sit up there and made a record about all this stuff that happened in Nevada. That's other acts evidence, ain't it? How was you allowed to put that on record and not even be truthful about everything that you said?
He's speaking about
one time did somebody say, no, we're going to strike that.
The statutory sexual seduction charge that he had from his.
If it had been me, it'd have been a problem.
His child's mom for impregnating her at 15. He didn't want that brought up. That's what he's speaking on.
Why was the bond not addressed? Why was the statement of particulars not addressed? No filings that I seen to file need to be addressed. After you sat there and told me that that's what I needed to do, then you want to refer to the waiver of counsel, which, again, for the record, you accepted it the way that I gave it to you.
Now he's going to play the victim card really quick. Listen.
On there, I do not waive my right to assistance of counsel. And you accepted that. But you still turn around and continue to violate my Sixth Amendment right.
So he wants to represent himself, but once he gets stuck, he wants to have the right to be able to call on an attorney to assist him, even though he had two attorneys that were appointed to him, and he didn't feel like they had his best benefit, his best interest at hand, because they wouldn't go along with the sovereign citizen stuff. So now you're trying to say that the judge was wrong because she wouldn't provide you with a standby attorney just in case you needed some assistance with some things, when everything was explained to him whenever he made the decision to represent himself.
First Amendment right by telling me what I can and can't say, which I have the right to say whatever I want to say and to be heard. That's the First Amendment.
Say it then, Darrell.
You sit up here and talking about a fourth option that you came with out of the blue for Illinois versus Allen when there is no fourth option. Then you try to sneak some other case laws in that you just came up with today. I don't know if you came up with that when you was on one of your breaks that you take. But that, it's awful funny that it never got mentioned before.
He is a mess.
You've repeatedly made a false record. You want to sit up here and perpetuate all this disruptive behavior and this, that, and the third, when you knew from the point of the start of this trial, one, that I wasn't prepared, two, that I did not understand the proceedings.
You knew that too. That's why you should have kept your attorneys.
Way to get around it. Just like you found a way to get around answering what your name was, which you're a public servant. The name that you have on file with the Secretary of Treasury and State, however you want to put it. You were asked for a certified copy of your oath of office, which you stated on the record you would not provide. Didn't give any case law why you don't have to provide that. Have yet to prove subject matter jurisdiction from the record. Have yet to show that you even have the license to practice law.
Ooh.
Haven't proven that yet. And neither has the prosecution.
Show us your licensure, Darrell.
Where's the licenses? Why can't I place your oath of office into the record? Why can't I make that part of evidence?
Tell them what you're mad for, Darrell.
The oath that you haven't even honored, not one bit. Doing enough to keep your face clean doesn't constitute being fair. Doesn't constitute being impartial. When the jury was selected,
shut them off, Judge. Shut them off.
Never got addressed in any way, shape, or form. When you were informed way before that I was striking the whole jury. So how can you go over that constitutional right, which I have the right to not pass a jury?
Darrell, you got.
Muting you. And the reason I'm muting him is because he has not addressed a single issue that was raised at the end of this hearing today. He's
still going. Look, he muted. He's still going.
Determinations of this court, I would describe it as a rant. He continues to impugn the integrity of this court and this process. Again, he did not address any of the issues that I raised at the end of this hearing. From my perspective, the issues that he is raising are all related to claims that a sovereign would make, someone who claims to be a sovereign citizen, claims that have no base, that are baseless in law and in fact. I'm not going to address them any further. Again, they are simply baseless. And
all right, we're gonna start right here. So I didn't show the part where she said that she felt threatened, but that did take place today. She said that she felt threatened, that she was afraid for her life. She put that on record. So I don't know what you guys think. This is like a wrap up, even though I'm just talking about today and some of yesterday. This is like a complete wrap up of the week because it was buffoonery the whole week. Guy definitely has some mental health issues that need to be addressed if they are not being addressed already. I mean, I know people don't want to hear it because, you know, he legit has some mental health issues. There's no way for him to do all of this that he's doing. And just the fact that he was able to run over those people like he did and just keep going. And I can honestly say, and I know people don't like it, I don't think he woke up with the intention that morning saying, I'm going to go and run over some people in a parade. But I do believe that rage kicked in at some point, and it may have been because his ex-girlfriend, he saw that she had another friend. And he was also supposedly upset about her, you know, not giving him money to bond out. Either way, he has some issues. He has some major issues. If his mom does take the stand, he is going to have another outburst. That is not going to be good. But as you can see, he was backpedaling a little bit on that because he never completed the subpoena. The judge approved for the mom to be able to come and testify. You see at the end, he had not submitted the subpoena to the prosecutor's office for them to go ahead and do what they needed to do. And because he made an issue about them assisting him before and he never asked them to assist, then they told him, if you want your mama there, you get him there, get her there yourself. We are not assisting with that. So he hasn't officially subpoenaed his mom to be there, but they said she can come voluntarily. So we're going to see if she shows up, because if he testifies and the mom testifies, and they will be the last two people testifying in this case. But I can only, I know a lot of people want to blame his mom because it's his his parenting. That man, 40 years old. He is responsible for what's going on with him right now. I mean, he's at the point, you know, you can look at the parents on some things. You can't blame his mama for his actions. He is 40 and some change. Okay? And I know these are behaviors that they have been dealing with for years. Now, did they try to help him get some of this stuff addressed? Who knows? You know, you got kids that are just completely out of control once they get a certain age. Like some of them you can't do nothing with. So I'm going to say that he needs to take responsibility for his own actions. It is what it is, because he got a lot going on. He's mentally unstable. His mom said he needs to be on medication. She did. But they did the test to see if he's able to stand trial, and he was, so can't be that crazy. She should never bail him out, though she probably kept doing it all his life. Probably so. And the thing is, Queen, from what I'm gathering, from watching the trial from the beginning, when he's not in 100 mode, he's reasonable. He seemed like he would be okay. That's what we looking at the charmer. He seems to be like he's okay, but once you take him there, that's a wrap. All bets are off. And you don't even have to take him there. Once he takes himself there, all bets are off. All bets are off. And I think that that's what happens. Like, even with a parent, you know, you see them doing all this bad stuff, but then it's still your child, and they come, mama, you know, this, mama, and you know, they bringing all this stuff, or dad, you know, they're bringing all this stuff to you, and you still, you know, you remember that's still my child, that's still my child. And, you know, you want to keep supporting your child, even if they're wrong, you still love them, you still the parent, you know, you still show support for your child, but you call his butt out and you hold him accountable for his actions. And that's what she said, he needed to be punished. But she's not the one that needs to make the decision on how much time that should be. That is what his mom said. So I don't think that she'll get on the stand and just go up there and try to lie for him. I think that will be the straw that breaks the camel's back, because if his mom gets up there and they cross-examine her, that's it. So it would behoove him not to put his mom on that stand. If he's really, like, if he takes some time this weekend and really try to think things over, then he will see that it's not a good idea to put his mom on the stand. It won't be good for him, and it won't be good for her. So if you love your mama, let your mama stay where she at. She don't want to be involved in it. She ain't coming up there. She's not watching. Let her stay at home and try to deal with a little bit of peace that she has. because sadly, some people, and I said, if you can identify as a parent, then if you know, you know. For some parents, I have been told myself that they don't, some of them are relieved that they had a child in prison. And I've heard this with my own ears because at least they know where they are. And for the most part, you know that they're safe. We know that's not always 100% the case, but they tell you at least they know. I've heard it. I can't tell you how many times I've heard it. Some people would tell you that it's the first time that they've been able to get a full night's rest in God knows how long. Because they didn't have to worry about where such and such was at or getting some phone calls about something. So I don't know. Where's his father? Let's stop putting everything on the mother. I don't know. I haven't heard any mention of his father. And I think the mom is only coming up because he had her car and she was the one that did the interview. And I think that's where the stuff is coming up with her. I don't recall hearing any talk of his dad in this situation, whether he was around, wasn't around. You know. So, guys, I hope y'all got something out of this. I will be watching on Monday. Like I said, I am zoomed in. I'm locked in every day. I'll probably come back on Monday because we'll find out if Darrell is actually going to testify. So that will be it's going to be an interesting day. And we will find out if his mom is going to testify. So all the way around is going to be an interesting day because I don't think that he's going to cooperate with the judge in that first part that she has to do that morning, the colloquy. I don't think he's going to be cooperative in that because he's oppositional. I mean, it is what it is. He is definitely oppositional. As an adult, he is oppositional. So I guess we have to stay tuned to see what else is going to go on with this case. Let me say my condolences to the families who lost their loved ones, and my prayers go out to anyone who was impacted by what happened on that tragic day. Darrell is included in my prayers as well because whatever hold he has on him, Lord, I'm praying that you help him see the way. That you help him see the way and accept the consequences of his actions. And with that being said, I thank you guys for tuning in. I thank you guys for participating in the chat. Again, hope you got something out of it. Shout out to the, I think we had 1 or 2 certified dimes that popped in here tonight. Mods, appreciate y'all. For the people in the chat, I freaking love y'all. This is why I don't have a lot of mods because we know how to do this thing. We know how to get this talk on and do this grown folk stuff. So I appreciate y'all. I appreciate the decorum. I appreciate the decorum in the chat. Can they give him a different judge or it's too late. It's too late, child. They're in the third quarter now. They're in the third quarter. And I don't think another judge would even try to take that mess on. I don't think he needs another judge. He needs that one. As all the stuff that she done sat through sipping, she needs to be the one to sentence that joker. All the stuff, all the abuse, the mental abuse that she has dealt with from him. And I know that don't sound right and that is completely biased. But she needs to be the one to sentence that joker. She need to make that final ruling because she has earned it. She has earned it, darn it, because she has put up with some mess from this joker child. Because woo, Jesus. Oh, Lord, everybody ain't able. Everybody ain't able. That's all I can say. Everybody ain't able. But yeah, you guys have a good weekend. I don't know. I might come back Sunday. I'm not sure. What's going on, Demetra? How you doing, lady? How you doing? It's just a lot. We may come back with a little inspiration, a word to shake some of the stuff off that we have been watching over the week, child, because this has been a mess. Good night, Lady Diva. You guys, again, y'all have a good one. Be safe out here because we got some folks right here. Y'all see it. We're watching it live. We got some folks that don't know how to act, y'all. So, be safe. Situational awareness. Be aware of your surroundings and what's going on around you at all times. Don't let them catch you slipping. All right. With that being said, you guys have a good one, and I will see you next time. Deuces.